Matter is posted tomorrow. It was not well for the entire week. So we are just requesting your lordship to take such a matter as an history.
No, it is fixed tomorrow. Only I will, as per your convenient, I will fix a date for hearing. You come, you ask the date when you will be available, then I will fix the date accordingly. Yeah, I think it will be better in month April because time will be there.
Yeah, have your lordship's kind leave, my lord. On notice I am mentioning, my lord, this is a originating summons suit in respect of, my lord, the Bandhan employees.
Yes.
Justice Saurabh Chakraborty was, my lord, appointed. His lordship held a meeting yesterday. Thousands of people in an auditorium. They were almost attacking him. Hijacked the whole proceeding, shouting at him. They just have one agenda, they want their money. His lordship, it's not possible. He was rescued by the police yesterday. We have requested his lordship to file a report. And, my lord, we shall be praying, my lord, for further orders. Kindly keep it as to be mentioned after 2-3 days. My lord, we have no difficulty because this is a huge problem.
Okay, you file. Let the special officer file the report.
Kindly keep it on Monday, my lord.
But what
Today we are on.
incident has been occurred?
Yes, your lordship can.
With the report, then I will pass appropriate order for giving police protection and whatever. It
Yes,
is.
but no further meeting really would be required. Let objections come in the form of applications before your lordship.
Correct.
And whatever order your lordship passes, whether it is for forensic audit, whether it is for anything, we have no difficulty.
Okay.
Lord, kindly let it appear on Monday, my lord.
Monday is non-commercial.
Whichever, my lord, is the next.
Tuesday,
my
Wednesday.
lord.
Wednesday.
Wednesday, my lord.
Today we are 26. 26 is to be mentioned.
Grateful.
Yeah, well, it's kind leave to mention a matter, my lord. The interim order is expiring today, but because there's a resolution, my lord, of early rising, my lord, because of a full court reference. My lord, if your lordship kindly, my lord, it's item 27, because there's a 3 p.m. fixed matter also, and it's your lordship's resolution. So, my lord, I could not take a risk, my lord.
Which one?
Item 27.
Ah.
The interim order is expiring today. I'm mentioning upon note.
I will, before rising, I will do that. Send any junior with the copy, I will do that.
My lord, may I permitted to mention one matter to be listed under the heading of undefended suit, my lord, the commercial suit, my lord, 120 days has expired, my lord.
Ah.
My lord, the register or suit register issued a notice certificate, my lord, that the 120 days expired, but till date no written statement has been filed, my lord.
To be mentioned after Friday.
No, when the return date of someone was served. Tuesday. Yes.
My lord, may I have my lord's kind leave, my lord, to mention a commercial suit upon notice. My lord, in this matter, my lord, a commissioner was appointed, but my lord, despite communications, commissioner is not, my lord, reacting to the.
Who is the commissioner?
My lord, Mr. Sinha, my lord. So, my lord, I am, my lord, praying, my lord, for the matter to be kept under
For what?
mention. Lord, for praying, my lord, of a substitute, my lord, because this is the third or fourth
Which for
time
the other side?
Mr. Banerjee is appearing on the virtual mode, my lord.
Your lordship.
Ah.
Since he was appointed for a long time, your lordship, there is no response.
Lord, in October 23, he was appointed. Thereafter, time and again, the time was extended on his health.
Commercial suit?
Commercial suit.
And Monday rakho.
Lordship,
CS com number.
this is my PLA 164 of 2024, Your Lordship. This was filed last year in April, Your Lordship. Till now, it's not been included in the list. I'm humbly praying for inclusion in the list, Your Lordship.
All have been completed.
Yes, Your
Formalities have been
Lordship.
Completed.
Yes, Your
Please,
Lordship.
you mention in the first week of March. I will take.
Lordship, kindly allows me, Lordship.
I am not allowing at present because I am already having 100 cases of PLA in my list. So I am trying how much it can be disposed of by this month, and I will take the mentioning from first.
Very well. I'm
first
so
week of the
grateful
month.
to Your Lordship.
Come on, first week of March, I will see it.
Where the lordship's kindly, this is a testamentary matter, my lord. Where citations have been completed by the paper publication has been
Come.
ready for grant of.
Come first week of March. Every PLA matter, no PLA matter will be taken as to be mentioned, sir. Yes.
My lord, one PLA matter amendment for application.
Come first week of March. I am already having 100 matters in the list. Let it be completed first.
Lordship, rectification of order, Lordship, when a PLA matter had come yesterday. Lordship, the date of the death of the deceased is incorrect.
Where you mention?
Yes, Lordship, on the first page of order, Lordship.
What is
Second
the date?
para. 23rd April, Lordship. It's not 20th April.
Only that.
Yes, and Lordship, the name of the attesting witness is Pessi M. Nadima. It's not Zareen Pessi Nadima, Dadina, Lordship.
Huh?
Lordship, the name of the attesting witness should be Pessi N. Nadina instead of Dr. Zareen Pessi Dadina.
Well, to be mentioned. मैंने correction में नहीं किया.
I'm
I'll
grateful.
लेके आना.
Lordship,
Yes.
may I be permitted to mention the 345 fixed matter?
हाँ.
Lordship, as today is a full court reference.
हाँ.
But this matter may be fixed in the second week of March.
Which matter?
Lordship, 345 fixed matter.
Non-commercial.
Non-commercial. Lordship, item 14.
Item?
14. Lordship, I have informed my other side.
Navas. Acha, that one. Yes. What do you want?
Lordship, anytime in the month of March, Lordship, second week of March.
Which one the other side?
Please
Your
appear.
Lordship, I am appearing for the plaintiff.
Yes.
On the last occasion, the defendant had argued, but they argued the application. They couldn't finish due to paucity of time, and the matter was fixed today at 3:45 p.m. Your Lordship kindly fixes any date in March, Your Lordship, for the same.
March नहीं वो अप्रैल में जाएगा. 25th of March at 3:45 p.m. 3 p.m. Item number 14. Original this non-commercial. So-and-so suffering for the plaintiff, so-and-so suffering for the defendant. And the matter is fixed today as 3:45 p.m. But due to the full court reference, the matter could not be taken up for hearing. Accordingly, case is adjourned. Let the matter appear on 25th of March at 3 p.m.
Grateful, Your Lordship.
Yes, call the
One, this was where they had filed an amendment application. We had sought extension of time.
My lord, this is my application, my lord, for amendment. My lord, this has come up at our instance.
My lord, the item 1 and 2, my lord, I'm late by Mr. Banerjee.
My lord, this application has come up at our instance, my lord, because my lord, the directions for filing of affidavits, they are not complied. My lord, yesterday, all of a sudden at 5:30, complied, my lord, after, my lord, we had mentioned the matter and has filed their opposition. Be that as it may, my lord, I do not wish to file a rejoinder because, my lord, there is nothing. It's a point law which I can. The matter is there on 13th of March. It's a simple amendment wherein, my lord, I have shown that from their affidavit only they have said that the shares have been transferred. So I just want to, my lord, have the hearing if it can be. Yes, my lord. Can it be preponed, my lord, to some other date, my lord? Because I don't wish to file a rejoinder.
Okay, I can prepone, but I cannot fix a time. I can prepone, but the time cannot be.
That is, my lord, so risky, my lord.
So that's why already.
Oh, my lord, I can.
22nd January, you booked on 13th March. Now you were prepone. I don't think there is any date.
Milord, can you take the risk, Milord, chance to do it today? Because Milord, we don't wish to file any rejoinder to their any reply to their opposition. If Milord takes it up today, Milord, it can.
As to be mentioned, how the hearing can be taken.
We did.
My lord, in that case, my lord, I don't wish to take a chance, my lord, because I have got a ticket for 13th. I don't want to miss that at least. So in that case, my lord,
come on,
yes, my lord, I'll come back because
reply file kore di.
No, not required. We'll not file it.
So-and-so suffering for the plaintiff, so-and-so suffering for the defendant, though the matter is fixed today as to be mentioned on the prayer made by the counsel for the plaintiff. But when the counsel for the plaintiff submitted, after mentioning the matter, the defendants have filed their affidavit in opposition.
File kore di.
And the plaintiff do not intend.
I find, my lord, Mr. Dashgupta.
I am saying that if you are getting time, if my lord
the chance,
matter, we will file the reply. We will take the chance. Why?
The counsel for the plaintiff press for time to file affidavit in reply. Let affidavit reply be filed within 2 weeks. Within 2 weeks,
we'll give them an advance copy.
In 2 weeks, after giving
in the meantime,
advance copy to the
we'll not take any extension.
It is fine from the record. The matter is already fixed on 13th March 2025 at 3 p.m. Let the matter appear on 13th March at 3 p.m.
But the original affidavit in opposition be kept on record.
The affidavit in opposition filed by defendant number
1 and 2. Item number
1 and 2. 1 and 2.
Kept with the record.
Grateful, my lord. Deep privilege.
Especially fixed matter.
My lord, in this PLA matter, my lord had directed newspaper publication in Delhi and Madhya Pradesh, my lord, in two newspapers, Indian Express and Dainik Jagran. Now the difficulty was there is no separate Bhopal edition for Dainik Jagran or Indian Express. So, my lord, the executors have gotten additional publication made in local newspapers in Madhya Pradesh. There are 4 additional newspapers, my lord. Will kindly take this affidavit at page 3, my lord.
Indian Express.
My lord, Indian Express and Dainik Jagran has been done for Delhi, my lord.
Okay.
For Madhya Pradesh, the additional ones were Pioneer, Free Press, and Nav Dunya. That's English and Hindi.
Pioneer and
Pioneer, Free Press, Bhopal edition,
Free Press.
Indore edition, and Nav Dunya. These are the newspapers which have circulation in Bhopal and Indore, my lord, and cover Shardol district.
What is the Hindi newspaper?
Nav Dunya.
Now Dunya.
Yes, ma'am. My lord.
So in Delhi you published in the Indian Express.
Yes, my lord.
And
Dainik Jagran, my lord.
And Dainik Jagran.
Annexure C, my lord.
Dainik Jagran, yes. And Bhopal?
For Bhopal, my lord, Pioneer.
The Pioneer.
Pioneer and Free Press, my lord.
Free Press.
Free Press.
Free Press, yes. And Hindi?
Hindi, my lord, Nav Dunya.
Now Dunya.
Yes, ma'am.
So and so appearing for the petitioner. The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. By an order dated 15th of January 2025, this court has allowed the petitioner to publish the notice in the English and Hindi daily newspaper, namely Indian Express and Dainik Jagran at Delhi as well as Madhya Pradesh. Counsel for the petitioner submit that in compliance of the order passed by this court, counsel for the petitioner submit that though the publication of English daily newspaper Indian Express and Dainik Jagran is available in the Delhi, but no publication of the Indian Express and Dainik Jagran is published at Madhya Pradesh. Accordingly, the petitioner has published the notice at Madhya Pradesh in English newspaper, The Pioneer, Free Press, FREEPRESS, Free Press, and Hindi newspaper, Now Dunya. NAVDUNI. So, counsel for the petitioner submit that as this court has allowed the petitioner to publish the notice in the Indian Express and Dainik Jagran, but in Bhopal, in the Madhya Pradesh, the said paper publication were not available. Accordingly, the petitioner has published the notice in the English notice, the Pioneer in the English newspaper, the Pioneer, Free Press, and in the daily newspaper, Now Dunya, but the department is not accepting the same. And praise for direction upon the defendant department to accept the said publication. In view of the submission made by the counsel for the petitioner, the department is directed to accept the affidavit affirmed by the petitioner, enclosing the paper publication made in Delhi in the English daily newspaper, the Indian Express, Hindi newspaper, Dainik Jagran, and in Madhya Pradesh, the Pioneer, Hindi newspaper, Pioneer, English newspaper, the Pioneer, Free Press, and Hindi newspaper, Now.
Grateful.
Malad, plaintiffs are outside jurisdiction. All the defendants are within jurisdiction.
What?
Malad, it has come at my instance. Malad, leave under clause 12. We have duly made averment in paragraph 27. Only in the prayer, due to inadvertent mistake, I had pointed out, Malad, the leave under clause 12 has been inadvertently omitted. So may that be with subject to my lord's leave, with hand correction, may we incorporate. Only paragraph 27. Malad, in my suit, Malad,
Pray for amendment.
Yes, no, not for amendment, my lord.
Addition of the prayer.
Additional leave under clause 12. That part was inadvertently, my lord, omitted.
Omitted.
That part. Man, para 27 is the pleading. At page 10, bottom.
Leave under clause 12 of the latest patent.
Yes,
There is no prayer in the prayer portion.
That man inadvertently
What
missed
about
out.
the concise statement?
Concise statement, I believe, my lord, there. Concise statement. No, consequentially must not be, my lord.
Group is not working.
Madam.
Total group is not working. Not going through the after the preparation of this.
Including me, I cannot, my lord, shrug off my liability responsibility.
Suffering for the plaintiff. The matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff. For the counsel for the plaintiff submit that in paragraph 27 of the plaint, the plaintiff has prayed for leave under clause 12 of the latest patent, 1865, but inadvertently in the prayer portion and in the concise statement, the said prayer has not been made. Accordingly, counsel for the plaintiff prays for leave to add the prayer for leave under clause 12 of the latest patent
by hand.
It not act.
No, by hand, I said.
Not act. Come to the page 11. Letter patent 1865 in the prayer portion before prayer A and in the concise statement. In the concise statement.
1865.
In some consider submission made by the counsel for the plaintiff. Plaintiff is granted leave to add the prayer for leave under clause 12 of the latest patent 1865 in the prayer portion as well as in the concise statement in course of the day.
In course of today. In course of today.
In course of the
day.
Full stop. It is fine. Full counsel for the plaintiff submit that in paragraph 27. Though the plaintiff has prayed for leave under clause 12 of the latest patent, but the act but in the said paragraph it is also mentioned that clause 12 of latest patent act 1865 counsel for the plaintiff intends to delete the word act. According leave is granted to delete the word act.
Yes.
In paragraph 27 last.
And would it be a lordship's pleasure? Would it be a lordship's pleasure to direct the matter to appear as presentation of plaint on any day subject to lordship?
After the amendment is carried
for
out,
the purpose of the leave.
Let the matter be placed before this
Tuesday.
court on Wednesday.
On Wednesday.
On 26th.
26th. Grateful
for presentation.
Your Lordships, I appear for the plaintiff in this matter. Your Lordships, I have instructions to withdraw this matter and I have instructions to withdraw this matter since the client has found some new documents which will help his case in limitation and the deception. So, Lordship, this is the case where CIP was admitted and the resolution plan was approved. So, Your Lordship, this client has found some new documents which will help his case.
You want to withdraw?
I want to withdraw, and Your Lordship, I'm praying for liberty to file afresh.
File afresh.
Yes, Your Lordship.
So suffering for the plaintiff. Counsel for the plaintiff. Though the matter is fixed today for presentation of the plaint, but the learned counsel for the plaintiff submitted there are some lacuna in the plaint, and the plaintiff has also obtained some document which is required to be disclosed in the plaint. Thus, the same cannot be cured by way of amendment. Accordingly, the plaintiff prays for withdrawal of the suit. Withdrawal of the plaint. Withdrawal of the plaint with the liberty to file afresh.
Gratefully, Lordship.
Consider the submission made by the counsel for the plaintiff. Liberty is granted to the plaintiff to withdraw the plaint. Liberty to file afresh on the same cause of action. Full stop. The plaintiff the court fee paid the court fee.
I believe so.
Where is?
I don't.
Not paid.
Lordship,
Nothing is there.
Then, Your Lordship.
Sure. With the liberty to file afresh, CS number 2 of 2025 is dismissed as withdrawn. Liberty to file afresh.
Grateful.
So this is my suit, my lord.
My lord, it's a suit for declaration and injunction. My lord, I'm only praying for order to rule to leave. My lord, my pleading.
Why order to rule to be?
My lord, I've pleaded that in paragraph 48 if my lord comes to of the plaintiff. My lord, this is a suit, if I may indicate my lord, the cause of action of the plaintiff, my lord. The plaintiff received possession of a property on Park Street, my lord, from the erstwhile lessee. Thereafter, certain third parties claiming to be associated with that erstwhile lessee are creating disturbances of the suit property and seeking to forcibly dispossess me. I am seeking injunctive protection and declaration of my rights as the owner of the property.
Why order to rule to?
Order to rule to paragraph 48, my lord, there are certain other damages which I have not been able to ascertain from the wrongful acts of the defendants. But I only seek to omit that part of the suit and file a fresh suit as and when I ascertain those damages.
Supreme for the plaintiff. The plaintiff has filed the suit, praying for the declaration that the defendant, their men, agents, servants, assigns, and representatives have no right, title, interest over the suit property and other prayers. Counsel for the plaintiff submitted that the plaintiff could not assess the total damage and there will be a chance that the damages can be increased and the plaintiff may pray for further damages. Accordingly, the plaintiff prays for leave under order to rule 2 of the CPC. Had the learned counsel for the plaintiff peruse the plaint and the materials on record. Leave under order to rule 2 of the CPC is granted. Plaint is admitted subject to scrutiny.
Deeply appreciated.
My lord, item number 7, may I have your lordship's leave to present the plaint for leave under clause 12 of the letters patent, my lord. The suit is for declaration, injunction, and seeking monetary decree before your lordship. The relevant pleadings are at paragraphs 21, 25, and 26. At page number 8, the Honorable High Court has exclusive jurisdiction to try and determine the suit since the money is payable to the plaintiffs at their residential address at 248 Robindra Saroni, Kolkata 7, which is within the jurisdiction.
Yes.
Terms of settlement was received by the plaintiffs within jurisdiction as aforesaid, and the same was executed also within jurisdiction at the above address. Over and above the aforesaid, the negotiations took place at 3B, 3rd floor, 12 Shakespeare Saroni, Kolkata 71, and at Hotel Astor situated at Shakespeare Saroni, Kolkata, just opposite to the residence of the plaintiffs, also within the jurisdiction of this honorable court, where the plaintiffs were induced to agree to the settlement without any backup support from any independent lawyer. Subsequent thereto, the plaintiffs, after meeting the learned advocates and after becoming aware of the legal position, time and again requested the defendants to take all action on the basis of the law of the land and demanded for setting it right. But despite such repeated request and follow-up, the concerned defendants have failed to act in accordance with law. Then your lordship will kindly take paragraph 25 from the deed of conveyance relating to the said property at Alipur, which is beyond jurisdiction. It is amply manifest that in spite of repeated requests made by the plaintiffs, defendants, and each of them proceeded with sale of the subject flat by making deliberate, willful, illegal, fraudulent misrepresentation, claiming that 7 except the defendant numbers 1 and 2, both the deceased do not have any other legal heir at all, and thereby perpetrating a fraud on the registering authority. Copy of the conveyance deed is annexed here too. Such registration was made before ARA 4 Kolkata within the jurisdiction of this honorable court. Now, pausing here for a moment, my lord, if your lordship looks into the prayers, I am essentially seeking a declaration that so far as the terms of settlement are concerned, that may be declared as void because under section 25 of Hindu Succession Act, there is a clear embargo that a murderer cannot take benefits arising out of the estate of a deceased.
Unless,
in this
unless it is proved.
unless it is proved otherwise. Now, so far as this matter is concerned, because of that, my lord, my preliminary prayer is that, and regarding the deed of conveyance also, I'm seeking a declaration. So it's a right in personam and not a right in rem, where I'm asserting right over the property in question. That is why prayer E has been made like that. Your lordship will find that internal page
Property
number
situated
12.
outside.
Yes, but this is not a suit for land,
Yeah.
because I am not claiming any possession of that particular land. I'm seeking a declaration merely in respect of that, because I'm saying that it is fraud perpetrated on the plaintiff.
Yes.
So therefore, my lord, it's not a suit for land, and also it's an ancillary prayer, because I have asked for, your lordship will find,
Inquiry.
monetary decree and also inquiry into the valuation of the property, and therefore reliefs in terms of monetary reliefs, so to say.
Okay.
So therefore, my lord, I'm seeking before your lordship leave under clause 12 only today.
So offering for the plaintiff. The plaintiff has filed the suit for declaration and other claims. Full stop. Plaintiff has prayed for leave under clause 12 of the latest patent, 1865, on the ground that part cause of action arose within jurisdiction and part cause of action arose outside of jurisdiction. Considering the submission made by the counsel for the plaintiff, peruse the plaint and the materials on record. Leave under clause 12 of the latest patent 1865 is granted. Plaint is admitted subject to
Grateful.
sponsor. 8. Wrongly listed.
No, my lord. Rightly listed, wrongly filed. What had happened was we filed 3 suits, my lord. 2, my lord, money lent and advanced. They were, my lord, non-commercial because it was a one-off transaction. This is not goods sold and delivered. This has to be commercial. When it came, my lord, we went through it and I discovered that it's, my lord, our mistake. My lord, please permit me to withdraw with leave to file afresh. And, my lord, the court fee, my lord, kindly, my lord.
So offering for the plaintiff. Though the matter is listed as under the heading presentation of plaint, but by an order dated 13 February 2025, this court has admitted the plaint subject to scrutiny by the department. Now the learned counsel for the plaintiff submitted. After going through the plaint, it was found that the dispute between the parties is commercial in nature, but inadvertently the plaintiff has filed a suit before this court, and as such the plaintiff intend to withdraw the suit with the liberty to file the same with the same cause of action before the appropriate court of law, before the commercial court. Consider counsel for the plaintiff further submitted prays for refund of the court fee, that the plaintiff can use the said court fee at the time of filing of the suit before the commercial division. Had the learned counsel for the plaintiff peruse the materials on record. Full stop. The plaintiff is granted liberty to withdraw the suit, liberty to file afresh with the same cause of action. Full stop. The department is directed to refund the court fee with the liberty to use the said court fee at the time of filing of the suit in the commercial division.
Grateful,
CS number 19 of 2025 is dismissed as withdrawn with the liberty to file afresh before the appropriate court of law.
And my lord, for the plaintiff, my lord, this is a suit for partition and injunction, my lord. There are a total of 12 properties. 5 properties are there for partition, my lord, and 6 to 12 mentioned in the schedule are bank accounts and demat accounts, my lord. That has to be refunded. That has been taken away by the defendant number 1. And this is a partition of the
within the jurisdiction.
3 properties are within jurisdiction, 2 properties are outside jurisdiction, 4th and 5th. That is why I prayed for leave under clause 12. And my lord, I have also prayed for leave under order 2, rule 2. My lord, in paragraph 32, I have mentioned, my lord, the account of the plaintiff was operated by the defendant number 1. My lord, their fraud has been committed. I have not been able to ascertain the damages, and I shall take out the appropriate suit for fraud and damages, my lord. That is why I prayed for order 2, rule 2. Mentioned at paragraph 32. What has happened? The defendant number 1 has operated the bank account of the plaintiff and taken out the money. And I have attached that bank statement also appearing at page 85. He has shown it as
Partition of scheduled property. What is the scheduled property?
properties are mentioned at 1 to 5. 1, 3rd, and 4th and 5th had to be partition between plaintiff, defendant number 1 and defendant number 2.
This is account.
No, my lord. 1st to 5th is properties, and 6 to 12 are demat account and savings account. That I have not paid for partition. That I have paid for refund. That has already been taken out by the defendant number 1.
So these are all within jurisdiction.
Yes.
First property. What is the first property?
First property is in Kolkata, my lord. Second property is in Kolkata. Third property is also in Kolkata. My lord. 4th and 5th are outside jurisdiction. That is why I paid for leave.
Outside jurisdiction.
Rajasthan, my lord.
KD Nagar scheme. Achha. By order to rule 2?
Paragraph 32. The defendant number 1 has operated the bank account of the plaintiff, which was lying with the father, my lord, at the time, the operation. And what he has done, he has taken some of the money from the account of the plaintiff, 12 lakhs and odd. And I have not been able to ascertain the damages for fraud, my lord. I will take out an appropriate suit. But the bank statement is also annexed.
Sense opening for the plaintiff. The plaintiff has filed the present suit, praying for partition and other prayers. Counsel for the plaintiff submitted some of the property situated within the jurisdiction of this court and some of the property situated outside the jurisdiction of the court. Accordingly, he prays for leave under clause 12 of the latest patent. Counsel for the plaintiff has also prayed for plaintiff has also prayed for leave under clause under order 2 rule 2 of the CPC on the ground that the plaintiff could not ascertain the total damages caused to the plaintiff, and there will be a chance that further damage may be assessed. And as such, leave under 2 rule 2 of the CPC is required. But the learned counsel for the plaintiff perused the materials on record. This court found that some cause of action arose within the jurisdiction of this court and some cause of action arose outside the jurisdiction of this court. Accordingly, clause 12 of the latest patent, leave under clause 12 of the latest patent is granted. Letter patent as well as leave under clause under order to rule 2 of the CPC is granted. Plaintiff is admitted subject to scrutiny by the
deeply obliged, deeply obliged.
Yes. Look, the partition suit, I am the third wife. First wife died childless. Second wife also died. The 5 children are there. They are the defendant in the suit.
No, they are the children of first wife.
Second wife.
Second wife.
First wife died childless. Second wife has got children. They are the defendant. The property.
Where the property situates?
Schedule A, B, landed F and G are within. And C, D, E is outside. That is in Bihar. C, D, E. A, B in Calcutta, F in Calcutta, G in Calcutta. We have also put in paragraph 6 also, Lordship. Husband died, my stepsons, they have taken the entire thing, business, landed property, everything.
Without partition.
So, without partition. And I have also annexed the Faraznama because according to the Muslim law, this is on page 70, which has been translated.
Yes.
My share is 12.5%. On the end, one wife. This has to be partition, Lordship. They will also get the share because they are the son of the original, I mean, my husband, Mohammed Mushtaq. 17.5, 17.5, 17.5. I will get 12.5%. That is what I am claiming, Lordship.
How many children?
5 children.
You are having?
I don't have a child.
You don't have only.
He died after it. There was a age difference.
So suffering for the plaintiff. The plaintiff filed the present suit for partition. Declaration. Partition and other prayers. Declaration, partition and other prayers. Full list of counsel for the plaintiff submitted. Some of the property situated within the jurisdiction of this court and some of the property situated outside the jurisdiction of this court. Accordingly, prays for leave under clause 12 of the latest patent. Consider the submission made by the counsel for the plaintiff, peruse the plaint and the documents available on record. Leave under clause 12 of the patent, latest patent 1865 is granted. The plaintiff is admitted subject to scrutiny.
Grateful.
And in this matter, I'm led by Mr. Rupak Ghosh. He was submitting the other day. That he's stuck in courtroom number 26.
He had concluded. I was supposed to begin.
I am told by him he needs further 5 just minutes. If your lordship passes over, he's stuck.
Okay, I will hear.
Yes.
Very well.
If Mr. Ghosh wanted to add something, he can add in the reply.
Very well.
But this is a review application which they have filed. Now, my lord, the first question is, before going into the modalities of review, one point which I would like to urge is, suppose there is a very minor correction in an order which has already been rectified on a subsequent date. Then, my lord, whether taking advantage of the same correction which was there in the original order, the provisions of Order 47 Rule 1 can be invoked. Because, my lord, Order 47 Rule 1 is different to a certain extent from the fact that any minor correction which does not affect the parties which have already been corrected. Order 47(1) is in the nature of correction which will have an impact on the final outcome of the order. Otherwise, if there is only a correction, instead of X, it should be Y, instead of son of X, it should be son of Y, which may not impact the final outcome, it will not be a case of under Order 47 Rule 1. And here I would like to show, my lord, your lordship had been informed of that particular error in the order, and your lordship has corrected that in the 9th October order. And I would show from their pleading in the Section 5 application, but to what extent they are going. They are saying that yes, we have knowledge of the 9th October order. We have applied for recalling of the 9th October order. So what prevented them, if at all, it was a case of review of an earlier order of 12th of April. Why should they wait to come to court after filing an application for recalling of a subsequent order which has already been corrected, the error, to file and come up with an application under Order 47 Rule 1? That is why, first, my lord, I will show your lordship, my lord, how, my lord, first of all, this review will not lie in respect of this correction. Number one, kindly see, my lord, have a look at that 9th October order once.
Yes.
This is in the affidavit in opposition, right? So page 60, or it is in a petition also, page 66.
Page 60 in the petition.
Yeah, GA1. Kindly see, my lord, the petitioner, second paragraph, Aloka Oja has filed the present application being GA25, praying for several reliefs, out of which prayer B for constitution of new interim board of the defendant number 1 company. Initially, Naveen Chandra Oja was the plaintiff. After death of Naveen Chandra Oja, his daughters Aloka Oja, Meera Seal were substituted. Pramod Oja died, and in his place, son Bhaskar Oja has been substituted. Defendant number 4, Maya Devi Oja, died, but she had no legal heirs. This is also an error. Next is 1, Anup Oja was brought on record being the legal heir of Chiman Lal Oja. This is the correction your lordship has done. In the parent order of 12th April, it was made that Anup Oja was the heir of Maya Devi, defendant number 4.
Correct.
So when the matter came up on a subsequent date, this was informed to your lordship and therefore this was already made. It is for your lordship to say that this should also be incorporated in that order of 12th of April. Now, therefore, my lord, I only say this. So October 9, 2023, kindly note this, they have filed an application for recalling of this order. That is GA number 27. Right?
28.
Sorry, GA number 28.
This is a 28. This
GA 27. Well, GA 27, if your lordship sees my learned friend's application, GA 27 was filed for recalling of this order of 9th of April, 9th of October, on the ground that lordship and the second part of the order has reconstituted the board. They are saying that I have not been heard. That is a separate matter. So when this application was filed, you are aware that 12th April has already been the error in the 12th April has already been rectified and has been recorded. Even at that stage, you do not come up with a review. Even before that, I will show.
So what has happened to the 27?
That is pending, my lord.
Pending.
Yes. Now it cannot be pending because the suit was dismissed. Only if the suit revives, that will revive. So when GA 27 was filed, 12th April stood corrected.
12th April order?
The order under review.
Yes. Correct.
12th April practically stood corrected. Even then, at that stage, they still could have come up with a review application if they so desired. That was not filed. Therefore, my lord, kindly comes back now to GA2, which is the, sorry, GA1, section 5 to Kunta. GA1. Kindly comes back to GA1. I would show your lordship, my lord, your lordship should not exercise discretion in respect of this GA1.
27 paragraphs gulo যেখানে he was aware of 12.
হ্যাঁ দেখো
Yes.
my lord, kindly comes to page 6 of that application.
Yes.
But section 5 is usually not taken by the other side very seriously. But this is a case where I have to show your lordship that if a party is aware of the order right from day one.
But Mr. Sen, if with regard to the name of the legal heirs is not correct in the parent order, what would be the effect?
That is what I'm saying. If that is corrected on 9th of...
Correct. That is with regard to the one. Because Mr. Ghosh has brought the attention of this court with regard to the other two.
But that is also a part of what I say, a correction.
Correct.
But it is not a case of Order 47 Rule 1.
That will see to that.
Yes,
but
that is my argument is that.
Yes, kindly come to the page internal page. This you are having the GA1.
Yes.
GA1 page 2022.
GA1 or GA2? GA1.
GA1 is a section 5 application.
Yes.
Section 5 application.
Section 5 application.
In that they have enclosed the order 12th April order.
Yes.
Correct.
Yes.
In the 12th April order, page 2022, inner page 6.
Yes.
Inner page 6, in the first paragraph, second paragraph. In the present suit, the father of the petitioner number 2 was the defendant number 2. And
this is correct.
Correct. And the mother of the petitioner number 1 was the defendant number 4.
This has been corrected by your lordship in on 9th of October. Kindly comes back to page 66.
66 of GS 28.
No. The 66 of the petition, GA1.
Yes, yes.
GA1.
66. Not 66, 60.
Yes, kindly come to the second paragraph. Defendant number 4, Maya Devi died. She had no leave. 1, Anup Oja was brought on record being legal heir of Chiban Lal Oja. This is the correction your lordship has done.
The Naveen Oja was the plaintiff, and after the death of the Naveen Oja, his daughters Aloka and Meera have been substituted. No problem.
No problem.
Pramod Rai Oja died, and in place of his son Bhaskar has been substituted.
Yeah, that is correct. Petitioner number 2.
No problem.
No problem.
Correct. Defendant number 4, Maya Devi Oja died, and she had no legal heirs. That is not correct.
They are saying there are 2. I have also said there are 2.
Yes. Now, one Anup Oja was brought on record being the legal heirs of Chimanlal.
This is correct. This your lordship has corrected it.
After the death of Chimmanlal Hoja, his wife Maya Devi. No, here they are what they are telling. This is one. This is page 22 of the J1 or inner page 6 of the order dated 12.
Yes.
The defendant number 4 was the petition number 1 was the defendant number 4, but after the death of the father of the petition, the name of the mother of the petition was deleted. So this is not correct.
That is what I'm saying. This part your lordship has already corrected on 9th of October.
9th of October.
By saying that Anup Ojha is the son of, as the legal heir of Chimanlal Ojha, not Maya Devi. The correct position has been incorporated. It's 66 number. Kindly see. Defendant 1 Anup Ojha was also brought on record being legal heir of Chimanlal Ojha.
Correct.
This is the correction which they are complaining of.
Anup Ojha was brought on record being the legal heirs of Chimanlal.
Chimanlal Ojha.
That's already done.
Correct.
And in the 12th April, it was said mother of the petitioner number 1 was defendant number 4. That is Maya Devi. This is the correction which your lordship has incorporated. If page 66 is read, defendant number 4 Maya Devi Ojha died.
66 of?
The 9th October. 9th October.
60, page 60.
60.
Yes, page 60.
Kindly read these lines.
Yes,
Defendant number 4 Maya Devi Ojha died.
Defendant number 4 Maya Devi Ojha died, but she had no legal heir. That is not correct.
That is not correct. 1 Anup Ojha was also brought on record being legal heir of Chimanlal Ojha.
So this is correct.
This is now corrected.
Anup Ojha was brought on record being the legal heir of Chimanlal Ojha.
Yes.
With regard to Chimanlal Ojha, there will be no problem now.
No
because he kindly come to the 12th April order.
Yes.
Fourth paragraph.
Yes.
In the last third line, after the death of Chimanlal Ojha, his wife Maya Devi has become the one of the member of the interim board of the management, was made as
that is also a correction. After the death of
Chimanlal Ojha, his wife Maya, that is not correct.
That is Maya Devi is not correct.
Yes, that is also
after
not
the death of Gunwant Rai Ojha, his wife Maya Devi became
one of the members.
One of the members.
It should be Gunwant Rai.
It was Gunwant Rai Ojha.
Correct. Gunwant Rai Ojha.
My point is, my lord, these corrections do not come within the aspect of Order 47.
Correct. Let me address that.
Yes.
Then we'll see whether it will be a review or what it is.
Correction.
Let me see. Because now instead of it will be a Chimanlal Ojha.
After the death of
Gunwant Rai Ojha. Instead of Chimanlal.
Yes. His wife Maya Devi Ojha became one of the members of the interim board of management and also made as defendant number 4 in the present suit. Perfect.
Correct.
Then, my lord, next page, Mr.
That is not first paragraph. There is no problem.
No problem.
Now,
admittedly, father of petitioners were shareholders. Also correct.
Correct. No problem.
Were also members of the interim board of management of the company, and after death of father of the petitioner, this is not correct. After death of father of the petitioner number 1, mother was inducted. This will be after death of Gunwant Rai Ojha.
After the death of
Gunwant Rai Ojha, Maya Devi, defendant number 4, was inducted as a member of the interim board of management. Not his mother.
Ojha, the mother was inducted.
Not the mother. It will be Maya Devi, wife of Gunwant Rai. Wife of Gunwant Rai was inducted as a member of the interim board of management and was also made as defendant in the instant suit.
Yes. Thus, the court is of the view that the petition number 2
shall be added as substituted defendant number 2. That is Bhaskar Ojha. That is not a problem because he is coming through Pramod Rai Ojha.
And the name of the petition number 1 shall be substituted.
It could be subject to correction. Name of the petitioner number 1 shall be added.
Shall be added.
Be added as a defendant in this, not 4. Because 4 is
Maya Devi.
Maya Devi's death has to be recorded.
Correct.
I should be added as a party.
Who is the petition number 1?
Anup Ojha.
Anup Ojha.
In fact, if I show your lordship my application, that is my pleading.
Added. Shall be added. And
as
the
a
death
part
of the defendant number 2 be recorded.
4 be recorded.
4 be recorded.
Recorded. If
Different-
your lordship not sees my application of GA 21, this was
shall
the
be added as defendant.
as defendant.
Substituted defendant. No,
It
not
should be added as defendant. Only added. Only
Shall
added.
be added. And the defendant number 4 and the
Name of the petitioner number 1 shall be added as a defendant
added as defendant
in the said suit.
as defendant. And death of the defendant number 4 be shall be recorded.
What is that?
Yes.
Now, if your lordship sees
Petitioners were substituted as a defendant number 2. This is again. These petitioners were substituted as a defendant number 2. Cannot be.
which line, my lord?
Last paragraph. Page inner page
Yes,
7 of
as the petitioners were substituted, no. As the petitioner number 2 is substituted as defendant number 2 and petitioner number 1 is added.
the petitioners were substituted. It is not correct.
Petitioner number 2 is substituted. Should be petitioner number 2 is substituted as defendant number 2.
As defendant number 2.
And the petitioner number 1 is added as a defendant.
And thus the petitioner and the defendant. How he has been defendant? What defendant?
I can be after defendant number 4. I can be defendant number 5. Whatever.
Then the petitioner. Thus the petitioner number 2.
But defendant number 4's name has been struck out.
Correct.
Because his death has been recorded. So I should come in
4A.
4A. Then, my lord, if we go by the cause title, then Sriram Oja will become 4 and I will become 5, whatever.
Then the petition shall be inducted as a petitioners. It cannot be petitioners. Then only the one petitioner.
No, 2. I am being added.
Petitioners shall be added. Shall be inducted as the members of the interim board in place of Pramod Rai Oja, not Maya Devi. Pramod Rai Oja and Gunwant Rai Oja.
No, Maya Devi was also in the board.
Maya Devi already there.
No, Maya
But she
Devi died. So her vacancy is also being filled up.
So who will come against the Maya Devi?
No one was appearing.
No one was appearing for Maya Devi.
Nobody is appearing.
Nobody had applied.
Correct.
Though
Maya
in my
Devi cannot-
application, if I should show my application para, I had said all branches since all branches should be represented. But none from
But
their
nobody is
branch
coming from the Maya Devi.
came. So, my lord, your lordship added us who came.
No, you already there.
There by virtue of your lordship's order.
Correct.
Before
But here the petitioners is both.
Yes.
But both, how the both can be now?
Petitioner is Anup and Bhaskar.
Correct.
So since your lordship's order was, since both are being added as parties, they will be inducted in the board.
Just a minute. Anup and who are the petitioner?
Well, come to GA 21, it will be clear. Kindly come to GA 21. Page 21.
GA 21 है.
Page 21 of GA.
बोला था ना GA 21 को लाने
No, it is annexed. Annexed. Well, kindly take GA 2, page 21.
Which page? Which GA 28?
GA 2.
No, GA 2 is annexed in which GA?
Review.
In the review. GA 2 of the review.
As of 1343.
Lordship says page 21 is the GA 21 starts.
Correct.
Kindly come to page 22. humble petition of the interveners, Mr.
Anup and Bhaskar.
Anup and Bhaskar. Now,
Correct.
your lordship will kindly come to para 8 and 9 first.
So Anup is with regard to the Gunwant.
No. Anup is with regard to Chimanlal.
Sorry, Chimanlal.
Chimanlal.
And Bhaskar is
with regard to Pramod Rai, who was the original defendant number 2.
That's why you persons are filing the petition by not giving the description. That was the problem.
Well, I'll show you, lordship. Just kindly give me 1 second, my lord. Kindly come to paragraph 13. Paragraph 13 at page 26. Paragraph 13.
Yes.
Petitioner number 1's father, late Chimanlal Ojha, died in 1994. And earlier I had said that Chimanlal was a member of the interim board.
Correct.
The petitioner had earlier tried to become a member of the board. There was obstruction from few of the senior members. Therefore, he did not proceed further to avoid acrimony and that he was working in a senior position, such and such. Next. Petitioner number 2 is the son of late Pramod Rai Ojha and represents his branch of the family and is authorized by his mother and sister.
Correct.
He had also made earlier application, was also faced with objection from senior members. Other 2 petitioners in the present proceeding are 2 surviving daughters of late Naveen Ojha, selling in the same board. Petitioner number 1 and 2 are agreeable to run the company under able supervision of the court-appointed chairman. Then your lordship will kindly come to para 18, page 28. Page 28, para 18.
Yes.
There has been a change in circumstances because of death of 2 of the members of the interim board of management. The petitioners are praying for leave to be added as party defendants and thereafter inducted as member of the interim board of management under orders of the court. Since the last few years, the company was run in a haphazard manner. There has been no news from Girish Chandra Ojha for more than 6 years. Pramod Rai Ojha too has died, and now Mr. Naveen Chandra Ojha has just passed away. There is only one Sriram Ojha alone surviving member of the board presently. Then in 19, is also important. Company needs younger generation to come forward. The petitioner states they have no objection if all the branches of the members of the then interim board of management are represented in the court-appointed boards. Petitioner feels that if the following members are added and are substituted, purpose will be served as all the branches of the family would be represented. Then kindly see, Gunwant Rai Ojha, Mihir or Amit is Maya Devi. Maya Devi and sons are this. Instead of Gunwant Rai, Maya Devi was already there. After Maya Devi, I have said Mihir or Amit as agreed between.
None of them came.
None of them have
But
come.
nobody has come.
Nobody has come. Then Chimanlal Ojha.
Gunwant Rai is the husband of the Maya
Devi. And then these 2 are the sons. I have named them.
Yes.
Then next is Chimanlal Ojha, Anup Ojha representing his family. Petitioner number 1.
Chimanlal Ojha, woman.
Anup Ojha. This is petitioner number 1.
Correct.
Naveen Ojha, Oloka and Meera.
Already there.
Girish Ojha to be as per consent because he is not
where.
traceable. Pramod Rai Ojha, Bhaskar Ojha. Petitioner number 2.
With regard to the Pramod Rai, Bhaskar Ojha, there is an order of the earlier court.
That also I have shown you, lordship.
December 2018.
Yes, I have pointed out that in my, they have taken that point in their affidavit in opposition. I have also dealt with in that reply. So the court was apprised of that situation. That order was in a different context and this is in a completely different context.
In that order, first, there were other board members.
There were already other board members. And not this situation that it becomes a standstill.
Single board member.
There is a sole surviving member of the board.
So what would be the effect of the order dated 3rd December 18?
With change of circumstances, that order cannot operate as a res judicata. Because of the change, your lordship is considering what is the change? That there is no board, one person.
Okay.
If one person cannot be a board, therefore, to undo this wrong, what your lordship is thinking of, all branches together, which was the parent board. First board was like that.
Yes.
And then kindly see kindly see what was my prayer at page 29. Prayer A. Direct Anup Ojha, being son of late Chimanlal Ojha, and Mr. Bhaskar Ojha, son of late Pramod Rai Ojha, representing each of their branches to be inducted in the interim board of management after adding them first as party defendant.
Yes.
So this was my prayer. Then now your lordship will see the
So
only
this is with regard to the GA
21, which was disposed of by 12th April.
That is the 12th April.
Yes.
Correct.
Now, my lord, kindly see 12th April, firstly was passed in the presence of this party. So when the order was passed, you were there. You were aware of this order. Then this matter was also mentioned. Kindly come to an order of 4th of May 2023. I'll just give your lordship the page. What I am trying to show your lordship is that a party who has knowledge of an order right from day one.
No, that I appreciate your, but if this court finds on the face of the record the factual.
Yes. No, I am not saying, but that I am saying cannot be an exercise of jurisdiction under Order 47, Rule 1. That court has a suo motu power even under Section 151. It can correct its own mistake.
And it has corrected.
Review is something else. Review is, it is such an correction which will have an impact on the final outcome. And that ground is covered by Order 47, Rule 1. You cannot go to any other ground. You cannot, now your lordship will take the memorandum of review. If your lordship takes the memorandum of review, your lordship will find that none of these grounds come within Order 47. So your lordship cannot invoke jurisdiction under Order 47 on the strength of this memorandum of review.
Okay.
That is my submission, my lord. Correction, I am not standing with the weight. It is your lordship's suo motu power under 151.
That's what I'm correct.
Absolutely correct.
Once it has been brought to the
Yes,
notice
yes.
and court has found,
But
it is a factually incorrect with regard to they are not challenging the law.
Then
the law can be challenged in the appeal. It is not the review.
Exactly.
Correct.
That is what I am
Law
saying.
cannot be challenged. It is in the, with regard to the
Error,
error
factual error.
appearing in the face of the record that has to be shown. Now they have shown. Now you are telling that this is only with regard to the
factual error which
can be corrected under the 151. It is not the ground under the review.
One part of it is already corrected, according to me, by 9th October.
Yes.
And for the purpose of these corrections, Order 47, Rule 1 cannot be invoked, and they have not invoked that. If your lordship now takes the review memorandum,
yes,
kindly take the memorandum. I will take each ground and show Order 47. Kindly see, my lord. For that there is sufficient reason, as the defendant respondent number 2 and 4 had not approached this honorable court with clean hands in moving GA 21. This is not a ground under Order 41.
Yes.
In spite of due diligence, it was not possible for the petitioner to bring the correct facts before the honorable court, as the same came to the knowledge of the petitioner after the impugned order.
Yes.
Which fact came to their knowledge? That I am the son of Chimanlal Ojha. Which fact, when they are saying due diligence, it was not possible for the petitioner to bring the correct facts because it came to the knowledge of the petitioner after. Which fact?
Yes.
That Maya Devi is the wife of Gunwant Rai. I am the son of Chimanlal. Which fact came to their knowledge after the order? Absurd. But they should be guilty of perjury. I will show that Section 5 application. Kindly see thereafter 3, there is sufficient reason to review, as late Maya Devi, original defendant number 4, was not the mother, who could not have been substituted or inducted into the interim board of management. This I have said 9th October, Your Lordship has corrected. And Your Lordship has recorded that Anup is the heir of Chimanlal. 4, there is sufficient reason to review the impugned order as respondent number 2 as suppressed material fact. Again, by not bringing on record that a similar application has been filed by respondent number 2, which has been struck down by this honorable court. This point is already there in their opposition and reply. So, this point cannot be considered in review. It can only be considered in appeal. Review is not an appeal in disguise. Suppression is not a matter of review. Even it is not a case of suppression, it is a point considered and rejected.
Yes.
5, Honorable Court failed to consider that the suit was filed against defendant number 2 for alleged mismanagement in affairs of defendant number 1 company. Respondent number 2, being son of defendant, is in no way affected by any adverse order, not under Order 47. 6, Honorable Court failed to consider the order dated 3rd December 2018. Again, that order. So it's a point of appeal, not of review. 8, Anup Oja is the son of Chimanlal Oja, Mridula Devi Oja, who are not defendants, and the same in spite of due diligence
Third at the top.
Of like deeply constituted. Yesterday, I had taken the Honorable Court to the orders of the NCLT.
Yes, yes.
The import of those orders is the import of those orders is that those proceedings are for mismanagement and oppression of the company.
Correct.
So inspection, financial audit.
Yes.
It's got nothing to do with the arbitral award. It cannot even otherwise have anything to do with the arbitral award because NCLT has no jurisdiction to get into matters which involve a fraud. And that the judgments, if I may just hand this over for this proposition, I had given it earlier also, but just to save time, I may just give another copy. I'll give a copy to my learned friend also. The court may be pleased to see the first judgment at page, this is at page 20. Yes. Para 18.
Page 20?
I'm sorry, page 20, para 35.
Yes.
For the applicability of the provisions of Companies Act 2013. It is well settled law that a serious question of fraud and collusion cannot be decided by the tribunal in summary proceedings. Given the relief and the court, if I may just read this and para 37, that I'll very quickly go through it. Given the relief solicited by the respondent number 1 in the suit for declaration, partition, injunction, tribunal has no power to decide the title of shares in summary proceedings, and this is for rectification and a summary procedure. Para 37, seriously disputed questions of title the Supreme Court has held cannot be decided by the Company Law Board, inasmuch as proceedings for the tribunal constituted under the Companies Act is summary in nature and seriously disputed questions cannot be decided by tribunal. Even if proceedings is initiated in tribunal, seriously disputed questions have to be relegated to civil court. And if the question as to title of person in whose favor the shares are to transfer, adjudication power may not be available to tribunal to exercise under Section 58 of the Act of 2013.
Yes.
The next judgment is that of the Delhi High Court, recent one, 2023 SCC, on page 25. Relevant part is on page 34. Para 1819, specifically with respect to Section 430 of the Companies Act, which my learned friend has cited, page 34.
Yes.
Para 18. Even otherwise, the case in hand cannot be adjudicated by the learned NCLT as subject matter of the suit pertains to fraudulent transfer of the transfer shares. The Section 59 of the Companies Act does not envisage the adjudication of the learned NCLT in relation to frauds committed by the company or individuals. In the present case, a specific woman's plain point was fraud committed by different number 1 and 2. The allegations of fraud are to be adjudicated upon only by the civil court through a detailed and meticulous process of trial before it. And so the court held the NCLT cannot hold the question of fraud as the plaintiff has taken a specific ground of fraud. Per Section 430 of the Companies Act. This is what my learned friend is relying on. Civil court jurisdiction is diminished only to the extent the learned NCLT is correspondingly empowered. A bare reading of Section 430 of the Companies Act 2013 makes it clear that the extent of ouster of the jurisdiction of civil court is directly proportionate to the extent of conferment of jurisdiction on the learned NCLT. Further, it is settled law the exclusion of jurisdiction of the civil court is not to be readily inferred, but such exclusion must either be explicitly expressed or clearly implied. There is a thin line obstructing the scope of jurisdiction of the learned NCLT. In the present case, the jurisdiction of the learned NCLT would have been exclusive if the matter truly pertained to rectification of register of members. However, if the issue is alien to the rectification of members, such matter would not be in the exclusive jurisdiction of the learned NCLT. And then the court goes on in para 22 to give a long line of cases of different high courts and the Supreme Court for the same proposition. I won't trouble the court. I can read the entire para. For the same proposition that the proceedings before NCLT are summary, questions of fraud cannot be gone into. So the question of my pleading fraud by
Tribunal cannot.
Tribunal can into it. So the scope and nature of the proceedings being different. That is not a bar. That is not a bar to the present petition. Here I must also point out that no such plea has been taken by them in the reply, in the affidavit in opposition.
No fraud.
In this court, when I filed my objections under Section Order 21, Rule 58 and Section 151, they filed their affidavit in opposition. The objections they've taken is there's no attachment when there is. They have said the property has been sold where it is still here.
Regarding 430, they have not taken any plea.
They have not taken, there's not even a whisper of defenses beyond the pleadings.
Okay.
The court may be pleased to take a note of that.
Hey, understand.
So the relief which is sought in these proceedings cannot be granted by the NCLT, and it's not even the case. What they had said before the Supreme Court in the counter affidavit was that these proceedings are pending.
Yes.
But in the reply to the objections which I filed, they have taken no such defense. So that takes care of the objection.
Yes.
Facts take care of the objection pertaining to NCLT and Section 430 of the Companies Act. Now, the last line of argument which my learned friend has taken is that this is a case essentially between Jagriti and Augustus.
Yes.
Nothing to do with us, which is Starlight, which is the holding principle. And so we don't have the locus in a way to even file anything.
Yes.
Now, I've already shown that it is our money, etc.
That you
But I would just want to take the court to to rebut this, one line from the joint venture agreement for the proposition, or where it's expressly said that Augustus will be solely owned by Starlight. The court will just see the joint venture agreement, which is part of my affidavit in opposition to the reply. On page, it's in the second volume, on page 109.
Page
109, the very first document, second volume. This is the joint venture of 2007 between Augustus and Jagriti.
Yes.
Page 111.
Yes.
In the recital.
Yes.
Augustus is para 111, clause 3. AALDPL is Augustus, is a company fully owned and controlled.
Yes, already P appointed, I take a note of.
Take a note. So I have the locus standi because, and it's also there's the same warranty is given on page 118 by Augustus.
Yes.
And the warranty is given on page 118 onto the same effect by Augustus in clause C. The reason I'm bringing this up right now is in light of my next submission, that there's a line of cases that even where a person does not have locus standi and fraud stays on the face of it and is brought to the notice of the court under 151 is bound to exercise state power to undo that damage. For that, I have given some judgments which are on record in my very first compilation. I'll take the Honorable Court to those judgments on this point, that divorce Order 21 Rule 5008, divorce standing, divorce issue of limitation, assuming everything against me, even then, the fraud which I have detailed on the earlier dates warrants invocation of Section 151. The first decision along these lines is case number 24, which starts at page 198. This was the Punjab Haryana High Court. And the relevant part.
Main citation?
Main citation, yes. Main citation.
Page?
The page is that the judgment starts at page 198, Punjab Mercantile Bank versus Kishan Singh. The relevant part is on page 212. I'll just read the very first just 2-3 lines on 212 and then come straight to 213.
212?
Yes. Where the court says, as a result of collusion between the judgment debtor and the auction purchaser. In this case, I'm saying between judgment debtor and the decree holder. In the instant case, a fraud has been practiced in order to gain unfair advantage.
Where from you are reading?
Page 212.
212?
Yes, the top of the page.
As a result of collusion.
I'm grateful. As a result of collusion between the judgment debtor and the auction purchaser, in the instant case, a fraud has been practiced in order to gain unfair advantage. This was the case where there was auction liquidator, and on facts, the court has said that the person who's revealed the fraud has nothing to do, has no locus standi. If I may simply come to the last line on this page, emphasis was laid on the fact that when the judgment debtor and the auction purchaser were agreeable to the confirmation of the auction sale, and the decree holder and the official liquidator in this case had not moved the court to cancel the sale, even if this court feels satisfied there's been led to an abusive process of the court, it must stay stand and not move in the matter so moved. I cannot induce myself to be party to proceedings where the real purpose of law to secure the ends of justice may be defeated by an underhand arrangement between two parties on the count of inaction of the third. The official liquidator, we can skip those lines because it talks about official liquidator. This is the case where Section 47 was not applicable. But if the court may be pleased to turn the next page, page 214, first paragraph, 5-6 lines from the bottom.
Yes.
Dharam Singh comes to picture only to extend that he is instrumental in revealing a fraud on court. Even if Dharam Singh has no locus standi, the court has ample reserve of inherent powers to satisfy itself so motu this process has been abused. Because the source of information happens to a person who has no locus standi, the court cannot close its eyes and decline to exercise its inherent power to set aside the sale on being satisfied that as a result of conspiracy, a fraud has been perpetrated and its process has been abused.
Yes.
So I'm relying on this for the proposition that assuming everything against me, that I have no locus standi, my funds have gone to...
The court found there is a fraud, then the court can invoke
the court has to, the minute it is, and for that, one needs trial. To establish fraud, I need trial. That is the reason why Order 21 Rule 58 contemplates a trial. And even for 151, it contemplates a trial. Because I'll just come to that aspect, but in two more judgments, very briefly, just one line from the judgments on this for the same proposition is the case number 22 on page 178 of the Madras High Court. So page 184. Page 184. First paragraph, 4 lines on the bottom. However, when fraud stares,
page
184. First paragraph, last 4 lines.
Yes.
However, when fraud stays upon the court can invoke its power to cite the sale. The application of revision petition can be treated as information to the court, and when a fraud is brought to notice of the court, it is the duty of the court to scan the said allegation to arrive at the truth. And then the court goes on to refer to the judgments, which I need not repeat or go through. But there are a whole line of judgments for this proposition.
Yes, then?
The final judgment is that of the Andhra Pradesh High Court, which is case number 23, which is at page 188. And the relevant para, the para 10 and 11, at page 195. Yes. Even otherwise, inherent power. I'm reading para 10 on 195. Even otherwise, inherent power in 151 also can be successfully invoked by the petitioner. The inherent power is addition to power the court is already possessed, and the court goes on to talk about misuse. And on the next column, last 4 lines, after referring to a large number of cases, the court says the division bench has held that though a person vitally interested in property has no locus standi filed application, when fraud is brought to the notice of the court, inherent power was exercised and sale was set aside. So these are cases for the proposition that in the extreme circumstances that I'm not found to have the locus standi, even then I'm entitled to a trial. Now, if I may just, I have more or less summarized whatever I've already more or less made my submission. But since this matter has taken so many dates, I do wish to just make one summary of the entire case. I had filed these objections under Order 21, Rule 58 and 151 in the ordinary course. It should have gone for trial. Because of the opposition in the realm of Order 7, Rule 11, that they have preliminary objections, the court has been pleased to hear detailed arguments on that, whereas this was supposed to be done post the trial.
Correct.
Now, when we're talking about the preliminary objections which they've raised, is no attachment. There is attachment. They say there is no money. I've shown money has been preserved. They say there was delay. I've said there's no delay because the division bench decided the non-suited me on 3rd of December 2019. I filed my SLP on 13 December 2019. I filed these objections on 26 December 2019.
That you have to clarify.
And everything the matter was adjourned at that point of time. So there's no delay. And even otherwise, provisos are a matter of trial. I've cited all that. I want to go through that. They then talked about, I've demonstrated the fraud because my application is also under 151. Their objections were res judicata, the liberty doctrine. If I go through the objections, it was basically that the order of the division bench is merged into the order of the Supreme Court, and that operates the res judicata. So I've already addressed that. And finally, they come to section 430, saying that those proceedings are a bar, which they cannot be apart from the fact they're not been pleaded. So my respectful submission in conclusion would be, is if the court finds on the basis of the affidavits that are entitled to the relief I'm seeking, and we need to await the issue of trial because the facts are more or less admitted, is all documentary.
Yes.
Then the court may be pleased to dispose of the matter accordingly. But should the court feel that I need to prove these documents, then this matter would need to go for trial.
Yes.
So with that, I conclude my arguments.
Thank you.
I'm grateful for a very, very, very patient hearing. If the court would like, we can give a short notice or in
Yes, let it go.
Mr. Bose is leading me, my lord. Lordship fixes any date for a composite reply on his part on the maintainability point, which he argued first, and then Lord reply on the merits.
Argue further.
Yes, maintainability, we have to give our reply to his submission.
This was my rejoinder.
Yes, and Lord on merits, because in maintainability argument, we did not argue on merits. Submit judgments have been cited at the reply stage.
Already you argue, you have given the reply, now he has given the reply. Again, what is that?
7 new judgments.
We'll file submissions, both sides.
With regard to the new judgments, okay, no problem.
So those
new judgment you want to further argument on law point, I will not allow.
Cited judgments have to be dealt with.
Yes, judgment you can deal with.
I'm a summary of our argument because we argued 4 months back. So the summary of our argument has to be there. So these two, any date be fixed, on that day we'll come and finish this.
I mean, I was hoping the baby both sides could file written submissions.
Correct.
And that was because it's been argued at length. Again, I'll have to respond to what they argue.
No,
then they will come, you will bring some evidence and that this judgment. Then
I'll have to argue. Not judgment. We'll deal with their judgments.
The last 6 months, it is going on like this only.
We'll have to deal with their judgment. That new judgments have been cited.
That's what I'm telling. With regard to the judgments which he has relied upon, you are free to deal with that.
Yes.
That is, there is no quarrel on
Absolutely.
that. There is no quarrel. But again, you cannot be allowed to argue.
Only I'm saying because we argued 4 months back, we'll give a summary of our argument. That's all.
Summary you can give in the written notes of argument.
Very well, on that day, that is what
you come. I am fixing a date. Come with the written notes of argument, and with regard to the judgment
on that day we'll make submission.
Distinguishing judgment. You come on.
Very
So and so appearing for the plaintiff. No, and decree holder. So and so appearing for the judgment debtor. Police counsel for the judgment debtor has concluded his argument. Police counsel for the decree holder prays for time to give reply by distinguishing the new judgment relied by the judgment debtor. Accordingly, as per the prayer made by the counsel for the decree holder, case is adjourned. Let the date hai.
If it would be at 2 o'clock someday, then I can just do if it would be at 2 o'clock on any date convenient.
2 o'clock, that is a problem.
Because
Till
then
April, my diary is totally packed.
Oh, I see.
3:45 कब है? 11 March. 3:45.
11th March.
11 March 3:45.
Could it
क्या
be?
date है? क्या
Could it
date है?
be 11th? I'm actually in Delhi. I have matters in the Supreme Court. Could be
Which
another
date
day.
you are free?
I can come on 10th if that's convenient.
Then
10th of
my
March.
date is not.
Oh,
My
I
diary
see.
is not.
12,
12, 13.
no,
12, 13.
13 March.
13 is Thursday.
13 March.
13 is Thursday. My appellate side matter.
Oh, I see. Then the court may be pleased to put it on 20,
उससे
it's
पहले कुछ
24th,
नहीं।
24th March if that's convenient.
Last week में कुछ नहीं। February में 11:30 कहीं है।
24th March if it's convenient.
कब है? 3rd March.
3rd March, very well.
3rd March 11:30.
11:30.
3rd March 11th.
Please complete on that. Record this. Both the parties.
We will complete. Lordship knows us. We will complete.
1 hour I am giving.
Yes, yes.
11:30 to 12:30
That's
you
more than
complete it.
sufficient.
Please, and please not to bring any new judgments. So
No, that's not the practice of this court.
both the parties are directed to come with the written notes of argument on the date fixed.
Obliged.
Grateful, Lord.
Lordship, I am for the petition. This is the matter with regard to appointment of a trustee in place of a deceased trustee.
Item number
13.
13. Huh? Non-commercial.
Your Lordship, we are on behalf of the trust. Kindly give us a 15 minutes passover. My senior is coming on his way.
15 minutes, my other determination will start.
5 minutes.
Sorry. Yes. What is the matter about?
Your Lordship, it is a matter about this, one trustee passed away. Then in place of the deceased trustee, the applicant has preferred applicant.
Again and again, I am telling this court is allergic to the adjournment, allergic to the passover. Whenever the court is fixed the matter, the advocate has to present here. If once the matter is adjourned, then it will go to the 3 months. Then you will say in the bar that the case is not being hearing, the court is not hearing the matters. Yes.
Your Lordship, in terms of
Which application?
ATF 4.
You are for the petitioner?
I am for the petition.
Yes.
Your Lordship, in terms of the order passed by Honorable Justice Ghosh, they held the meeting and appointed a trustee who is appointed a person other than the applicant. We went for appeal and the appeal court has remanded back this matter on the point that the minutes of the meeting should be placed before this court.
Correct. That has been placed in by a supplementary affidavit.
Yes, and for that we have filed exception.
Correct.
They were to satisfy the court on the point that why they have not appointed the applicant.
Yes.
My lord,
Lord, a closing statement, my lord. If your lordship kindly takes, my lord, the opposition, the supplementary affidavit, my lord.
Yes.
Now, before, my lord, taking the supplementary affidavit, my lord, kindly bears in mind that before Justice Ghosh, my lord, when, my lord, initially, when the Section 74 application was placed, my lord, they took the point that, my lord, if I am being appointed as a trustee, the other members would not get a chance, my lord. That was tested, and that, my lord, point has been decided against them. Secondly, my lord, the only, my lord, exercise that was provided to the remaining trustees was to see who was the senior member from that particular family. Now, vis-a-vis this, kindly takes, my lord.
No, on the last occasion, only you have taken the time. You will go through which clause of the deed the
Yes.
resolution has been taken.
Yes.
That is no where is the instruction?
Your lord,
Have you the February 6 order?
yes,
Yes.
yes, your lordship. My senior is on the legs. He's coming, but as per instruction, he has prepared a brief notes on whatever submission he is going to make. May I be permitted to submit the brief notes?
Sorry. Yes, you gone through this.
My lord, I'm now, my lord, going through, my lord.
Okay, you go through. Come on the next day.
My lord,
Senior is also not there.
Already 2 years.
my lord, subject to correction, my lord. The point which has been, my lord, enumerated in paragraph 7.
No,
Deepest
kindly
lord,
come 11. 11, 12. They have described how this.
that is exactly my case. This is not as per the trust.
That's why they have taken the same thing on the dead on that day also.
Because at the time when the resolution was framed, kindly takes, my lord, page 17 for once of
Page?
page 17 of their supplementary affidavit.
Yes. Yes.
The last paragraph, it starts from the word Dr. Pushpen Lal Shil. And such in support of their connection have stated that as per the trust deed, it has been stated if a post fallen vacant due to the death of one of the 4 trustees of the family branch of late Gobindo Lal Shil, only the brothers, kindly marks this, my lord, only the brothers starting from the eldest as per the sequence of that person's family falling therein.
Correct.
So what my learned friend is now trying to include and say that the person who has been appointed is, my lord, from the family branch. Whereas
He is the senior most.
Yes.
And that's why.
And that is not the case over here. Because from the petitioner's family branch, he is, my lord, the eldest, and it has to be considered like that only.
The brother starting from the eldest as per the sequence of the personal.
That family branch.
Correct.
So that family branch, if your lordship takes, my lord, the genealogical table, my lord, in my family branch, my lord, I am the eldest.
You are the eldest.
The person who has expired, my lord, no legal heirs is there.
That's
so
right.
automatically, my lord, I, my lord, come into existence. My lord.
That is the problem because the person Amyo.
Yes.
Amyo died.
Right.
So there is no legal heirs.
No, there's no legal heir.
So in place of the Amyo, who will be the trustee?
Right.
Correct.
Right.
So as per your contention, you being in the lineage, you are the senior most, one legal heir of the senior most. So you will be get. So they are telling no, it cannot be because Naren Lal.
Narendra is there, and the reason he has given is, my lord, kindly see. They further, paragraph, page 18, internal page 2, they further submitted that the trustees from the branch, the second paragraph, my lord, Govindolal Shil would be opportunity to be a trustee. Admittedly, such and such was already a trustee in the board, and there is a likelihood of his appointment in the next board, also considering the sequence of rotation. Henceforth, to give an opportunity to others who have not been appointed for a long time, Mr. Such and such should be appointed at the vacant. So this is, my lord, the reason. It has not been, my lord, the person who has now been appointed is not appointed on the basis that he is senior.
Correct.
So, and that this Millard point is already Millard agitated before once Millard decided against them. And on the same basis, Millard, this person has been appointed.
Yes.
My land junior has submitted a short note.
Yes, I got it.
For your lordship's consideration.
I got that.
Lord, may I request you to come to the order of the Honorable Appeal Court once. Order dated, my lord, 18 September 2024.
Yes.
Now, my lord, kindly come to the last paragraph of page 2.
Yes.
My lord, accordingly, we modify the impugned judgment and order date so and so by directing that the application would be pending.
Correct.
The main application filed under section 74. The decision of the board shall be placed before the court for consideration.
Correct.
Upon hearing learned counsel for the parties, the application made thereafter be disposed of finally as early as possible, preferably by so and so date.
Correct.
Now, my lord, in terms of this order, my lord, prior to passing of this order, the board has taken a resolution. In that resolution, my lord, after demise of Omiyanath Sen, the vacancy fell. So, my lord, there were 9 trustees. Out of 10, there are 9 trustees as on that date. The 9 trustees held a meeting. 8 out of 9, considering, Lord, the...
So that's why on the last occasion, kindly see the 6th February order.
6th February order, yes.
6th February order.
Yes.
Consider respond phrase for time to ascertain how and under which clause of the deed the resolution has been taken by not appointing the petitioner. Which clause of the
Yes,
deed?
Lord, that
Show me
I have
that.
done.
Because you have to act in terms of the
Yes,
deed.
of course, I am bound
So
to.
that's
I am
why
bound to.
on the last occasion the same question was asked for by this court. You have taken the time. Show me which portion of the deed which you have taken the disease.
একটা কাজ ঠিক করে বলছি মানে the only thing is the original deed of trust was in vernacular. In that deed, I shall place that the relevant portion, which according to me, subject to correction, as have been annexed in the petition. This is not the verbatim reproduction of the Bengali language used by the
Okay, okay, I am sending this to the department. You pay the
that
cost?
is why, my lord, I was
for
humbly
official
submitting. That is why, my lord, the exact true translated copy.
Okay, okay, then if you are disputing with regard to the translated
It is
copy,
apparent from the Bengali and
okay, that's why I am not blaming you, sir. If you are taking that plea, then I am sending it to the department for official translation. No problem.
Either your lordship or myself, I can both
Deepest
any
of
of us
respect,
can
my lord.
do it.
This Millard translated copy was there, Millard, at the time of initiation. And when I had moved Millard the section 74 application. No point taken with regard to that. Millard, opposition file, no point taken.
May I read out?
Now, Millard, he's coming up and saying, Millard.
No question now or then. This is a question of translation. Millard, may I read? Millard, your lordship may not understand. My land friend will definitely understand. May I just read the relevant portion in vernacular? ঈশ্বর গোবিন্দলাল শিলের বংশধারা হইতে বাই রোটেশন, থ্রি ইনগ্রেডিয়েন্টস আর দেয়ার, বাই রোটেশন পর্যায়ক্রমে প্রতি 5 বছর অন্তর ট্রাস্টি নিযুক্ত হইবেন এবং এই রোটেশন পর্যায় জ্যেষ্ঠ পুত্রানুক্রমে আরম্ভ হইবে, মিনিং দেয়ার বাই but that it will be by rotation, number 1, and then in every 5 years,
tenure of the 5 years.
Yes.
Then
and the important thing is porjayakrame. What is the sequence wise? Now, in my note, I have stated, your lordship will kindly see what is this thing. I have stated.
11.
Kindly come to paragraph 11 of this note. after the demise of Amyanath Sen, as per by rotation based on seniority and sequence and seniority. Three ingredients are there.
What is the meaning by sequence?
Sequence means, my lord, rotation, or Brojolal, my lord, there is a rotation, specific rotation every 5 years.
Correct.
Now, my lord, if your lordship looks at this table,
every 5 years is the time limit.
for
Rotation,
Brojolal,
rotation with regard to once it has been given the 5 years, the next year he will not be continue. Then the seniority will maintain.
yes. Now, kindly come to the annexure to this note.
Yes.
I have prepared a table.
Correct.
Your lordship will see at the top.
Where is your legal schedule?
That is the annexure to the petition.
Page 108.
107.
107 is, my lord, the different branch.
Yes,
We are
108.
concerned with the
108.
branch, yes.
108.
108.
Yes.
Now, my lord, here from the present branch, your lordship will see from the first column, as per sequence, Pierilal, from Pierilal's branch.
What is the difference of the sequence and seniority, sir?
My lord, my lord, in the third column, your lordship will see.
No. Kindly come to your this schedule which you have prepared.
Yes.
How you can come to what is the difference between the sequence and the seniority?
Sequence means, my lord, after one branch, the next branch in terms of the, my lord, order will come subject to the seniority of that
branch.
group.
That branch.
Correct. Here, my lord,
so seniority will maintain first.
Yes, that your lordship will see here itself. In the fourth branch, from the branch of Bolailal, Narendralal has been appointed. In C, Narendralal has been appointed. Narendralal is much senior to Joyanto from the branch of Maniklal. Generation.
How the rotation? You left the rotation.
No.
You have to come for the rotation, then the seniority, then the sequence, then the seniority.
Rotation in my humble submission in terms of the trust deed.
Okay, I will record
only.
I will deliver my judgment on your sequence, seniority, and rotation. How is to be.
My lord, kindly allow us to get the translated copy so that
I am satisfied for that. I'm not required.
Rotation.
I understand. And other side is the other side knows the
rotation, my lord, in my humble submission cannot be without the sequence and the seniority.
Correct.
Sequence and the seniority.
Correct.
In terms of the seniority, my lord.
Seniority with regard to that years. Sequence of that years.
That years, my lord, after Maniklal.
Not you. You will not go to the sequence of the third generation.
Kindly visualize. Let in the third column, Joyanto will belong to the 6th generation. And Narendralal, who has been appointed, he is in the 5th generation. And he is much senior to Joyanto.
Maybe.
That
next time when he will be retired, you will get an opportunity.
In the last board.
Sorry.
He was there in the last board.
Maybe where is the provision? If it is seniority, it will come. It cannot be continued.
It is not there. Then, my lord, then the only other thing is, my lord, if Narendra is not appointed, Joyanto's turn in the next board will come. And Joyanto was there in the last day, and the trust says the decision of the majority trustees will be
That's
final.
why on the last occasion I specifically directed under which clause you are telling. You have now shown the clause. In the said clause, it is not stated that the senior most of the lineage.
No,
it is not there. Senior most of the rotation of the sequence.
Rotation wise, my lord, if Maniklal is escaped, then, my lord, the rotation of Bolailal comes.
Then why will it escape?
After Brojolal, Bolailal comes.
Then?
And from Bolailal's family, Narendra is the senior most. The turn of Narendra should come, my lord, in my house.
Anyhow, I should not be appointed. Okay. This is, my lord.
I will pass out.
In any event, my lord, he will get his turn in the name.
Exactly. Okay, I will. This court will interpret your all the things.
Great.
If you are again, I am giving the time to sir. Otherwise, it will very difficult to your trust in future. Also, every time you have to come to the court. I am telling you. On last occasion, I also warned you, but you have brought again new things.
Not new thing, my lord.
This is a new thing. Sequence, seniority, and the total.
That is what exactly
your deed is totally simply. It is to go to the rotation. tempered with
My lord,
seniority.
your lordship has to construe
How you come
my
to
lord,
the
how the my lord, rotation comes.
I know, sir, how the trust
the
is
rotation
how the
comes.
trust is being maintained by all the persons of the trustees. This court knows. Every day, 2 or 3 trust matters comes here.
My lord, your lordship is the base judge.
That's why I'm telling. That's why I'm telling. I am giving another opportunity to consider it instead of the order of the court. Then your Narendra will never be in the trustee.
I will. Narendra possibly not.
Never be in the trustee for the last 10 years.
Narendra, we do not know whether Narendra will survive for the next term.
That's why I'm telling you, he will never be for the 10 years. As per this chart which has given, he will never be the trustee for the last 10 years. I know why you wanted to bring him. If as per this chart, Narendra will never be as a trustee for 10 years, sir.
That is also the desire of
now the truth has come.
Truth, 8 out of 9 has agreed to his appointment.
Maybe. It is not necessary now. 8 persons are not agree with him. Not having a good relationship with him.
But it seems that the trustees
You have to act in accordance with where is the majority. When the deed provides that the majority is to decide.
Yes.
Instead of this seniority as per that clause.
No, deed specifically says that decision of the majority will be final.
So that
in case of any inconvenience, the decision of
inconvenience.
Lord, here in my humble submission, Lord, some inconvenience has been incorporated.
Okay, you wanted to continue with these provisions? You wanted to continue with these provisions?
I shall stand beside it.
Okay. Stand with this.
Sir, stand with this.
Yes. What is your contention?
My lord, first and foremost thing is, my lord.
That's all?
Yes.
Yes.
I cannot develop it.
Your lordship has seen, my lord, the clause. And
which clause you're harping upon?
My lord,
The last occasion, sir, you're not comply with the order. You're not comply with the order of the 6th February. Yeah, you're not. I am hearing you. You're not complied with the 6th February.
Show your lordship, Lord.
You have not complied with the 6th February order. Yes.
So, my lord, page 19 and page 20 is, my lord, the basis how, my lord, the trustee will be appointed in case of a rotation from the branch of Govindulal. And if your lordship kindly takes, my lord, the genealogical table after, my lord, page 108, after Johorlal, whose legal heirs and there is no but.
First is now the Amyo. Amyo expired.
Amyo expired.
Correct.
Yes.
Now the seniority has to come by rotation.
By rotation.
Correct. Now come to
so
the seniority.
Johorlal branch is abolished.
Seniority. Yes.
So Pyarelal.
Johorlal, there is no
legal heirs.
Now it has to come the rotation with seniority. Correct.
Right. So
now the seniority will come the Pyarelal.
Right.
Pyarelal is the seniority.
Yes.
Yes.
One trustee is there from this branch. Brojolal's branch, my lord, no legal heirs is there.
Pyarelal, already one trustee is there. That is the
Soumendrolal.
Soumendrolal.
Yes.
Then
my lord, Brojolal,
there is no
legal heirs, but there is, my lord, in the matter of a reversionary right. So my lord, Pushpin and Punno is there from Brojolal's group. So after that, automatically, if by seniority,
Brojolal, there is already there.
Brojolal, yes, by reversionary right.
Already there.
Yes, already there.
So there is no vacancy.
No vacancy.
Second seniority.
So automatically, Maniklal will come.
Now the third seniority is the Maniklal.
Maniklal, I am only there.
You are the only
Yes.
there. So you are Jayantolal. You are the Jayantolal. Correct. Now they have come with the Narendra.
Right.
Correct.
Right.
Narendra has coming to the Bolai.
Bolayala.
So they are bypassing the Maniklal.
Right.
And they are giving to the heirs of the Bolayala. And giving the Narendra. Their contention is the Narendra is senior to you. So that's why in the rotation, in the sequence and the seniority, that's why the seniority is the Narendra.
And kindly takes into consideration, he adds to this, my lord, by saying that I am 6th generation and Narendra is 5th generation. So, my lord, this aspect is absolutely, my lord, not there in the trustee. So what he is trying to, my lord, give is the external aid in interpreting, my lord, the trustee, which is, my lord, not permissible.
That's why a given chance they are not coming with the same. How they can interpret? Yes.
And my lord, the order itself is very clear. Their exercise is to find out who is, my lord, the senior.
But my only submission would be that seniority and sequence wise, my lord, not interested.
Okay, I will record you.
You are not sure.
No problem. I record your submission. But in future, you mind, sir, once the court has passed an order, please to comply with.
Lord, I am sorry, my lord,
Instead of
6th February
instead
order,
of making
I
an
should have
argument before
considered,
the
my lord,
court,
it was not before me, 6th February order. I am
instead of
very sorry for that.
for the last 10 minutes, I am telling your junior, they are not understanding.
Lord, even now it is not there, my lord. I am very sorry for that. I should have.
So you have kept so many juniors, they are not having the 6th February order. And without the last order, you are arguing the matter before the court.
Very sorry, my lord. I should have considered.
And you come with a written notes of argument without considering the last order.
Yeah. And I have no explanation to that.
Sense opening for the petitioner. Sense opening for the respondents. The petitioner has prayed for an order to appoint the petitioner as trustee in place and instead of deceased trustee Amyanath Sen. Sen, S-A-I-N.
S-E-I-N.
For residue period of 5 years in the present board of trustee formed with effect from 21st of February 2022 ended with 20th February 2027 as per the trustee dated 27th of January 1947. Full stop. Initially, the present application was taken up for hearing and by an order dated where is the order of Justice Ghosh?
My lord, I had handed over, my lord, on the last occasion, but it is supplement.
By an order dated 12th of July 2024, this court disposed of the present application by passing the following. This one. Paragraph. Page 12, last this one. Set out. Okay. Being agreed and dissatisfied with the said order, comma, the petitioner had preferred an appeal before the appellate court, prepared an appeal being APOT number 299 of 2024 with ATA number APOT number with GA number 1 of 2024. The Honorable Appellate Court by an order dated 18th September 2024 has disposed of the said appeal by passing the following. This one. Page 2. This one. Not this.
সেই জন্যই তো জজ বললো আমি অফিসে ট্রান্সফার করাচ্ছি।
In terms of the order passed by the appellate court, comma, the respondents have filed supplementary affidavit disclosing the resolution number T-16/M-64 dated 9th August 2024, wherein the trustees have taken a decision. Where is the decision? Which portion?
My lord.
Taken a decision.
Page 18, second last portion.
English.
Eight.
Taken the decision.
सर आगे पेजটা দেখেন আপনি যেগুলো লিখা আছে
Last but one and the last paragraph.
page 17 last portion.
This page number 18. Following decision. Taken the following decision.
Second paragraph of page 18, your lordship will kindly
Page
consider.
18.
The second paragraph.
So this one, page 18 plus 1, 2, 3, 4 paragraph. The counsel from the petitioner has filed exception to the said supplementary affidavit. Where is the exception?
Not it's filed.
When you filed?
It's
January,
filed.
February 25? 5th February
5th February 2025.
Taken the exception.
কি বলেছে? কি বলে?
By stating the following. This page 7 here to this. Okay. Counsel for the respondents. Counsel for the respondents submits that. Counsel for the respondents submits that after the death of Amio, say, as per by rotation, based on sequence and as per seniority, after the branch of Johar J-O-H-A-R Lal Seal, the branch of Boloy Lal Seal should come. He submitted that Narendra Lal Seal, being the 5th generation member of the senior most from the branch of Boloy Lal Seal, has been nominated. And accordingly, out of 9 trustees, 8 trustees have agreed to appoint Sri Narendra Lal Seal, being the trustee, in place of Amio Nath Sen. Counsel for the respondent submits that the petitioner Jantu Lal Seal, hailing from the branch of Manik Lal Seal, being the 6th generation, junior to Narendra Lal Seal, should not have been nominated, as Kanak Lal Seal, hailing from the branch of Bolay Lal Seal, also could have been nominated in the board of 22-27 after the demise of Amionath. He submits that Kanak Lal Seal did not apply for the trusteeship because he was in the board with the Jayanto Lal Seal for the tenure 2017-2022. Learned counsel for the respondent submits that the petitioner Jayanto Lal Seal was the trustee for the year 2017-2022, and as such, the board has taken a decision that he cannot be repeated as a trusteeship after the death of Amio, and the Jayanto Lal Seal will get his opportunity of the trusteeship in the said trust from From which year? 27.
2022 to 27.
No, 27.
27 to 32.
27 to 32. 27 to 30. Full stop. So, per contra, an advocate appearing for the petitioner submits that the resolution taken by the board and by the trustees is in violation of the trust deed. He submits that Amyo Nath Sen, being the branch of Jawaharlal Sil, died, who was the trustee for the year 2022-2027. There is no legal heirs of Jawaharlal Sil after the death of Amyo Nath Sen. Now the trust has to decide who will be trustee in place of in place of Amyo Nath Sil, as per rotation, sequence and seniority. Counsel for the petitioner has drawn the attention of this court to the chart of the legal heirs of Govindalal Singh. Govindalal, not Singh. Wherefrom it reveals that Pyare Lal is the senior most. Subsequent to Pyare Lal, the second one is the Brojolal. Third is the Manik Lal. Fourth is Bolai Lal. Fifth is Amrit Lal. Sixth is Kanjalal. Seventh is Gostolal. And eighth is Jorlal. Now the Jawaharlal family, no legal heirs of Jawaharlal, no legal heirs of the Jawaharlal family after the death of Homyo. Now the seniority has to be taken into consideration from Pyare Lal onwards. The legal heirs of Pyare Lal is already in the trust. Pyare Lal and Brojolal are already in the trust. The petitioner is the legal heirs of Jayanto. Manik Lal, who is seniority, who is third in seniority. But the respondents have chosen not to appoint the petitioner, Mr. Jayanto Lal, who is the heir of Manik Lal, and have taken a decision for appointment of Narendra, who is the legal heir of Bolai Lal, who is coming in the seniority of fourth in seniority. Full stop. Learned counsel for the respondent submit that Narendra Lal is the senior in age, and as per the deed, seniority and the sequence is to be taken into consideration. He submits that the trust has taken into the sequence and the seniority and found that Narendra was the senior most, then the Jayanto Lal. Thus, the trustees have appointed Narendra Lal, ignoring the candidature of Jayanto. Considering the above, this court find that the decision taken by the trustees, full stop. Last bola, the trust deed, where is that portion?
Yes.
Page 80?
Page 18 and 19. 80, sorry, 19. 19 and 20.
Full stop. The clause of trust deed shall be, the relevant clause of trust deed shall be read as follows. Page 19, this one, then this one. As per the clause of the trust, if the family branch of late Govindalal Sil, any post, of the 4 posts of trustees became vacant on the aforesaid ground, comma, in that case, the post shall be nominated according to seniority only by a person who is a member of the person's family and who is eldest in age, either the brothers or their absence, the eldest of the sons of their descendants. In the present case, the trustees have taken a view that Narendra is the senior. But the trustees have not taken into consideration before the Narendra, the family of the Maniklal, who is number 3 in the seniority, is to be taken into consideration. If the Maniklal third seniority of the Maniklal is to be taken into consideration, he will be the senior most than the Narendra. And if the Maniklal seniority is to taken into consideration, the petitioner will be fitted in the vacant post of the trustee instead of Narendra. Considering the above, this court find that the decision taken by the trustee by a resolution dated 9th August 2024 by appointing the Narendra is in contravention to the trust deed by ignoring the candidature of the petitioner. Accordingly, the resolution dated 9th August 2022 with respect of appointing Narendra is set aside. Accordingly, full stop. The trustees are directed to immediately convene the meeting and take appropriate decision for appointing the petitioner in terms of the trust deed by maintaining the roster and seniority.
For the tenure 22 to 27.
For the tenure of 2022 to 2027.
Residuary. Naturally, this hardly 2.5 years.
Correct.
Only thing, Lord, in that case, Lord, he will be the trustee for 3 consecutive terms.
Maybe what can be done? There is no.
I quite get it.
That's why on the last occasion I asked you, where is the cutoff? If it is permitted, he is not entitled for the next year.
That there are trustees who are there, for
Correct.
5
That
long
80A
years.
number 76
Okay, 50 years, they are continuing.
But kindly record only one thing, Lord. I have drawn your lordship attention to page 15 of the vernacular trust deed that your lordship has not considered. Kindly record that only.
जहाँ में दोनों को ट्रस्ट डीड को कोट किया, उसके नीचे लिखना है, the counsel for the respondent has submitted that this translated version is not correct to that of the Bengali version. But this court find that since the year 2023, the case is going on, but the said objection has not been raised, and this translated copy has also been relied by the appellate court.
Grateful.
I'm grateful.
Yes, sir. Yes.
Item number 15, my lord, your lordship, it fell from your lordship that it will be 10:30, my lord. And so
today?
Yes, on the last occasion when I was arguing and I closed it, then it was lordship's pleasure that it will be may it be 10:30 tomorrow.
Tomorrow. Who is for the other side?
I mean, other sides are here.
What is the matter?
No, this is Calcutta Swimming Club.
Calcutta Swimming Club matter. I am for the plaintiff, my lord.
That one.
Well, at 2 o'clock, my lord, for other matter also. At 3 also, there is another fixed matter.
We had given a oral assurance, so if this matter could be heard out.
Okay,
we'll give it some time.
tomorrow 10:30 कर.
Tomorrow 10:30.
कल 11 10:30 है 10:30 come
10:30.
Grateful.
Yes.
At item number 50, I appear for the petitioner, my lord. On the last occasion, I have complied with your lordship's order by publishing the advertisement in terms of section 283(3) of the Succession Act in Hindi and in English. Thereby, your lordship directed to publish it in Hindi. My lord, we have caused the publication, my lord. The affidavit of service be kept on record.
Have you obtained the no caveat?
No caveat obtained.
After when the publication was made? When the publication is made, sir? 23rd January.
23rd January, my lord.
So today we are on 18th.
18th, my lord.
19th.
19th. My lord, in any event, my lord, all the legal heirs have given their consent. This was in compliance with, because there was no citation has to be issued in any of the legal heirs. So it was your lordship's direction in compliance of section 283(3) to make a publication in Mumbai, because one of the immovable assets are lying in Mumbai.
So you have to obtain this. Okay. Since suffering for the petitioner. Petitioner has filed affidavit of service in compliance of the order dated 22nd of January 2025, showing the publication made in the English daily newspaper Times Inter at where it is Mumbai, at Mumbai. Let
Now,
the same be cut
Times on 23rd January in Maharashtra.
at Maharashtra. Let the same be cut with the record. Full stop. Department is directed to submit the report whether in terms of the publication made by the petitioner dated 23rd of January 2025 in the English Daily.
English Daily, my lord, on the last occasion we have already filed the
made by the petitioner in
the English Daily, the
the
Times
English
of
Daily.
India, 9th January 2025.
Yeah, bola. The council for the department is directed to furnish the report whether any caveat is lodged or not. Within a week from date, let the matter appear on 3rd March. Next.
Grateful, your lordship.
51 lordship, Advocate Juidatta Chakraborty is appearing. Advocate Juidatta Chakraborty is for the petitioner. She is right now under surgery at Fortis Hospital.
As per the prayer made by the council for the
Kindly,
petitioner,
lordship.
let the matter go, maybe list in the monthly list of March 2025. Maybe placed in the monthly list of March 2025. Yes, next.
Grateful, lordship.
This is my application for amending the application for grant of probate, my lord. The proposed amendments are formal in nature.
Who is for the other side?
Well,
Nobody.
this is prior to issuance of citation.
Yes, what amendment you are
Well,
sought for?
there were certain averments made. This was a change brief, my lord. There were certain averments made in the petition which are not relevant for the purpose of adjudication of, my lord, application for grant of probate. So, my lord, we had to delete a substantial part of the original application and introduce the necessary pleadings for the purpose of the grant of probate. My lord, if your lordship is pleased to come to page 8 of the application.
8?
Yes, my lord.
Yes.
My lord, this is what we have introduced.
Where is the proposed amendment?
No, that is the proposed amendment. It's in, I believe it's in red. Lordship has
Okay, the PLA.
application code, sir.
Where is the application? Okay. PLA already so much.
Yes, well,
What
that
are-
is why I was quite surprised. It's not necessary because there's some history to it. That's why perhaps, my lord, it's become bulky. My lord, first proposed amendment, my lord.
So you want to delete all these things?
Yes, my lord. It's not necessary because, my lord, it becomes a plaint. If I have to prove all these facts, my lord, I will be in some difficulty. I don't need to prove. I only have to prove the execution of the will and, my lord, the mental capacity of the testator.
For probate or letters of administration?
Probate, my lord. There's a will. The original is already in the records of this honorable court.
So suffering for the petitioner. Petitioner has filed the present application being GA1 of 2025 in PLA 199 of 2024 1. praying for amendment in the probate application by deleting some of the paragraphs and by adding some of the paragraphs. Consider the submission made by the counsel for the petitioner, peruse the proposed amendment. This court finds that the amendment as sought for by the plaintiff petitioner is formal in nature and will not change the nature and character of the present application. Accordingly, prayer A to C of the master summon is allowed. GA1 is disposed of.
Only one thing, my lord. The portions which have been struck out, it's in red. It should have been in blue ink. Lordship will kindly direct, my lord, if it can be taken on record with that red ink itself. Otherwise, the department might object.
No, they will not.
Very well. Great.
For the caveatrix, my lord. My lord, time to file the affidavit in support of caveat was extended by the Honorable Division Bench for it peremptorily for 2 weeks, my lord. This is the order, my lord. We have filed by the course of this day within time.
When the order was passed?
On 11th, my lord.
2 weeks fast. Oh.
No, my lord, it was filed. Today
I will
filed.
serve the copy.
I will serve by the course of this day or tomorrow.
Where is your affidavit of? Where is your affidavit?
It was filed in the department, my
I don't know.
My lord, I have to receive notice as well.
Yeah,
I
my
have
lord.
not received.
This court can, how the court can know?
My lord, it was filed in the department and I do not get any receipt, my lord.
Pick it up tomorrow, my lord, if it commences tomorrow, so that we can.
I will serve by the course of this day, my lord.
Pay for the usual directions, my lord, for conversion to a testamentary suit.
Then, my lord, kindly do not fix it tomorrow. I have some personal difficulty. Any day.
So-and-so appearing for the petitioner. So-and-so appearing for the caveator or
caveatrix.
Caveatrix. Counsel for the caveatrix submit that in compliance of the order dated order passed by the appellate court dated 11th of February 2025, the petitioner, the caveatrix has filed the affidavit in support of caveat today in the department, and he will serve the copy of the same to the learned counsel for the petition in course of the day. Full stop. As the full stop. This court find that the affidavit filed by the caveatrix is not on record. Accordingly, the case is adjourned. Let the matter appear. On 24th, department is directed to place the affidavit of caveat, affidavit in support of caveat filed by the petitioner in the record of PLA number so-and-so. PLA number 175/2022. By the next date fix.
Grateful.
Next.
Lordship, I am on behalf of the petitioner. This is an application for the letters of administration. And here the petitioner is the only legal heiress. And
why the letters of one? He is the only legal heir. Why you filed the application? He is only legal heir. Why the administration?
Because some properties are there, as you can see.
Property is only legal heir. So why the administration is required?
That is. And the father of the deceased died long back in 1974, Kirot Kumar Chatterjee, and the mother of the deceased, Bina Chatterjee, she also died in 1967, much back. So, apart from the petitioner, there is no other legal heir, and the deceased died on 2021, May. 25th May 2021.
Where is your application? What is the name of the deceased? Aurobindo
Chatterjee.
Chatterjee. What is the name of the petitioner?
Chitra Chatterjee. Srimati Chitra Chatterjee.
Hey, PLA. PLA ka? PLA? Yeah, PLA. Aurobindo Chatterjee.
Yes.
And you are Chitra Chatterjee.
Yes.
Where is the legal heir? Chitra Chatterjee.
Yes.
So what about the death of the Aurobindo? Where is the death certificate?
Death certificate is Annexure A. You can find.
Arbindo.
Yes.
What about the wife?
Chitra Chatterjee is the wife.
wife?
Yes, a petitioner herein.
Only. There's
Yes.
no issue.
No issue.
Where is
Childless.
where is the averment? There is no issue.
Yes, I have mentioned that. Childless, it is mentioned in the main petition. I'm showing you, Lordship.
Issueless leaving behind.
Yes.
Him is only. Yes, we got. So appearing for the petitioner. The petitioner has filed the present application for grant of probate, grant of letters of administration of the properties and credits of the deceased Aurobindo Chatterjee, Aurobind, Aurobindo Chatterjee. Aurobindo Chatterjee. Counsel for the petitioner submitted that the deceased died on 25th of May 2021, leaving behind the petitioner being the wife as his sole legal heir. Counsel for the petitioner submitted that there is no issue in the wedlock between the petitioner and the deceased. Where is the affidavit of assets? Where is the affidavit of assets?
Affidavit of assets is here only.
Consider the submission made by the counsel for the petitioner. This could find that the deceased died leaving behind his wife and there is no legal heirs. Deceased died on 25th of May 2021. After the death of the husband, the petitioner has filed the present application. Considering the above, this could find that the petitioner is entitled to get the letters of administration to the estate of the deceased, subject to furnishing bond of rupees. Where is the affidavit of asset? What is the total value of the property? 58 lakhs.
58 lakhs.
58,000.
58,000.
And 36,000.
Yes.
Of 58,000 and 38,000. 1 lakh. 10,000. 10,000 with one surety. With one surety. PLA census. This
one submission. Can I get the order without being drawn up? Just a kind submission.
Department directed not to drawn up the order.
Lordship, much
Not
grateful.
to complete and drawn up.
Obliged.
Next.
55, I am for the plaintiff, Your Lordship.
Wait, please, my lord. I appear for
57, I am for the caveat.
the plaintiff in 56 and lord caveat is in 55 and 57.
I'm appearing on behalf of the petitioners in.
There are 3 suits.
Three suits, my lord, connected of the same gentleman.
Lord, pursuant to your Lordship, earlier direction, Your Lordship, of 22nd of January, we had taken inspections of the documents, Your Lordship. But the only thing, Your Lordship, we could not affirm the affidavit. And further, my lord, we intend to move an application with regard to filing caveat in support of against the other two. Other two suits.
He has not filed his caveat, my lord. Affidavit in support of caveat within time, my lord. This is what he is
There was
meaning.
no
that he
directions
should-
on our part because
But
we did
my
not
lord, Lord, be that as it may, my lord, your lordship had
use an
directed.
affidavit, Your Lordship. We want to
Your
use an
lordship had directed.
application for that.
Who is for the plaintiff in TS4? You are for
He is the plaintiff in TS4.
And what about TS24?
I am the plaintiff, Your Lordship.
You are for the plaintiff. TS25?
I am the plaintiff.
So you are three are the plaintiff.
Yes, my lord. My lord, I have filed my affidavit in support of caveat in both these applications.
Similar to
Issue and my lord, I have also, my lord, filed my suggested issues. So has he, my lord. But my lord, he was to file in terms of the order dated 22nd of.
So in which case you wanted to file the affidavit in support of caveat?
In both, Your Lordship, titles of 24 and 25.
24 and 25.
Yes.
Who are you? Who are you?
I am the petitioners in this.
Who are you? What is the connection?
No connection.
No
Because
connection.
it's dealing with the same will
Huh?
of a same testator. 3 separate will was
You are one of the executor of the will or beneficiary of the will. One will of the TS4.
TS4.
So why you not filed the caveat till now?
I
No
requested them
application
for,
as on
I
board, my
requested
lord.
them
Your lordship may kindly, my lord,
requested for
proceed.
supplying copy.
My lord, we have already filed. It's there in my lord's record, my lord. Today, my lord, has been fixed for fixing of the issues, for framing of the issues, rather.
I'm seeking some time, Your Lordship. I could not affirm
the
it.
court cannot grant the you may file. How the court can grant time to file affidavit in support of caveat, sir, without the application?
That's where we could not. But we will file it, Your Lordship. But that for that I'm seeking time, one week's
For
time.
what?
For filing if
You
that
file.
petition.
The court cannot grant in this suit to file affidavit of caveat. Affidavit in support of caveat.
No, in this, Your Lordship, title suit 4 of 24, my lord, we could not affirm the affidavit also. Affidavit in support of
Affidavit is with respect to the documents, my
Let
lord.
the issue be framed.
Let the issues be framed.
But his affidavit is not there. How the issue can go?
Yes.
Then tomorrow he will come with an application.
No, my lord. What I mean to say is, my lord, that there has been repeated non-compliance of my lord's order. Your lordship may kindly seize the earlier orders. My lord, everyone is coming, my lord, to my lord, seeking time on one ground or the other. My lord, today, your lordship.
When you entered into the suit 24-25?
My lord, just your Lordship has directed both all these 3 applications to come up. That is in the month of
because
November.
all connected. When you entered into the title suit 24 and 25.
We did not, Your Lordship.
You're not entered.
We could not. Because
You're
we
not
didn't have.
entered.
No.
You're not entered. So
then how can you file?
How you can file this? So TS4. Give the TS4 ka file do. There are 3 wills.
Three wills, not of the same gentleman.
Which is the last will?
Last will is of my learned friend.
And that is a TS4.
Yes, that is TS4.
Yes, where is the suggested issues?
Your lordship may kindly seize, my lord. I had filed it.
Give the suggested
original. My lord, we both have filed it, my lord.
আমাদের কার এটা আমাদের তো আর ওদের এই তোমার ইস্যুটা দাও দিয়েছি আগে তোমার দাও না আছে তোমারই কপি আছে দাও না
on behalf of the plaintiff of 23.
এটা আমার
23. CD 24, 23 last say. What is the TS 23 or 24?
24 is mine.
23 is also there.
23 is
yes.
23 and 25.
23 and 25.
24 and 25.
Who has filed this 23? Suggested issues?
But there is no such TS 23.
Who has filed this?
একটু দিন তো এটা দিন তো
There's some mistake, Your Lordship.
This is a typographical mistake on his part.
Correct it.
Correct. But my issue and his issue, my lord, can be added, my lord. Two issues by each.
You are not given issue.
Not
You not file the issues.
No.
He was to file in terms
you are
of
coming to every day and taking adjournment and going and sleeping.
first
and when
time,
the court
my
is
lord,
disturbed, then you're coming here.
First
you come
time.
on
This is the first time I'm seeking adjournment. I've never sought for any adjournment.
Every day the matter is listed. This is the 22nd January matter was listed. What is a good name?
Lutful Haq.
Then
Lord, he appeared, he sought for time.
Your Lordship directed me to have inspection. I had had inspection, but I was to file my affidavit, but that I could not. I didn't seek any time. Earlier I didn't.
Seeking the time does not arise, sir. It is your choice. If you want to enter into the matter, you have to take appropriate steps. The court cannot advise you.
No.
He has to file
Yes,
his
you have
caveat
to
in
file.
support of-
Till now, the court is not having any caveat from your side in either 23 or 24. Or 24 or 25.
Lord, rather we have
Lord,
filed our affidavit
my
in
lord,
support of caveat.
What has happened, my lord, in my case, Your Lordship, we made the advertisement. and they did not. So I sought for your lordship, made letters, wrote letters to them for supplying me with a copy of the application. That was not done.
Which
So I
one?
did-
Which case?
In both the cases.
When?
You are appearing in which case?
I'm title suit 4 of 24.
So how they will give the copy of the 24 and 25 to you? You are not the party here.
No.
So why they will give? You are not the invitee.
No.
Then why they will give? Unless you enter.
Subject to correction, no, my lord. Letters have been
Even though
written to us.
written, why they will give? You are not the party in the 24 or 25. You are the party to the 4.
Yes.
So you are 24, 25. You have not taken any steps. What? No, why they will serve to you?
And no
Unless you have been added as a party.
And no communication also, my lord.
So
My lord,
what
by
you
an
want?
order, my lord, all these 3 suits have been
One-
connected.
1 week's time, your lordship, so that in the meantime I can come up with
In
necessary
which case?
application. In all the 3 cases.
24, 25, you have no locus. What about the 4?
Since
4, where is the suggested issues?
suggested issues, I'm yet to file my affidavit of documents. So give me 1 week's time, your lordship, so that I can file my affidavit.
So and so appearing for, what is your good name?
Lutful Haq.
So and so appearing for the plaintiff in TS 4 of 2024. He submits that the discovery and inspection of the documents have been completed, but the affidavit of document could not be filed as the affirmation has not been completed. Accordingly, he prays for time. Full stop. Number next. The counsel for the plaintiffs, so and so appearing for the plaintiff in TS 24 of 2023. And so and so appearing for the plaintiff in TS 25 of 2023. The plaintiff in TS 4 of 2024 is not the party in either in TS 24 of 2023 or TS 25 of 2023. As till date, the plaintiff in TS 4 of 2024 has not taken any steps to be added in TS 4, TS 25 and TS 24 of 2023 and TS 25 2023. Counsel for the parties in TS 24 or 25 have filed their suggested issues. But this court find that all the 3 suits have to be heard analogously. And TS4 is not ready for framing of issues. Accordingly, for framing of issue is deferred. Time to file affidavit of document by the plaintiff in TS4 of 2024 is extended for a further period of 1 week from date. In the meantime, the plaintiff in TS4 of 2024 is also directed to file the suggested issues after serving the copy to the learned counsel for the defendants within a week. Full stop. This is the matter on 4th of March 2024. 5th of March 2025.
May this direction be peremptory.
It is made clear that on the date fixed, if the plaintiff in TS4 of 2023 failed to file the affidavit documents and suggested issues as directed above, the suit will be proceeded accordingly.
Obliged, lordship.
Extremely good.
So this is my application for grant of probate, my lord.
Yes.
It is deceased.
Yes, sir.
Yes. Look, the deceased has died, leaving behind 3 legal heirs, the executives, and 1 son and daughter. Mother, father, and the wife of the deceased predeceased him.
It's not working.
Hello.
Yes.
Yes, my lord. My lord, after the general citation has been no consent.
Grant of probate.
Yes, my lord, grant of probate.
All the project, all the
Yes, my lord, everything has been done.
Yes.
After special citation, one of the legal heirs could be served and the other could not be served. And substituted service has been directed, my lord, by way of paper publication. That has also been done. No caveat has been, my lord.
Where is the will?
Where is the will?
Krishna Das Raha.
Yes, my lord.
He is the executor.
Yes, my lord.
Yes. Where is the name of the test? He is the tester. Where is the name of the executor?
Executrix, my lord. Madhuchanda Raha.
Where it is?
The daughter.
Madhuchand Raha.
Raha.
Executrix. Yes. What is the date of the will, sir?
Date of the 18th December 2020.
18th December 2020.
And testator died on 5th August 2022.
5th August 2022.
Yes.
Where is the death certificate? Yes. Where he died?
My lord, he died at America, my lord. United States of America.
Commonwealth of Manchester. Yes. How many legal heirs?
2 other legal heirs, my lord. 1 daughter, 1 son.
Where is that?
My lord, if your lordship checks up the affidavit affirmed by Madhuchandra Raha dated 21st May 2024. Second page.
Raha. Whether they have filed the consent?
No, my
These
lord.
two?
No consent has been filed.
Consent has been filed.
So special citation has been issued.
What about the wife?
Wife predeceased.
Where is that?
Predeceased on 14th May 2020.
Where is that? Death certificate enclosed.
Your lordship will find death certificate has been given. Lord, your lordship will find at paragraph 5, page 2 of that
What is
affidavit.
Pratima Raha?
Pratima Raha.
She died when? 2020.
She died on 14th May 2020.
14 May 2020. And testator died on 2022. Before that.
Yes, my lord.
And special citations were issued.
Special citation issued.
No caveat.
No caveat till now.
What about the attesting witnesses?
Attesting witnesses. Affidavit has been filed.
Chakravarti.
Yes, my lord.
Only one witness has come.
Bharat Chakravarti.
One witness has given or both?
One witness, my lord.
One. And suffering for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament of the testator Krishna Das Raha, dated 18th December 2020. Counsel for the petitioner submit that the testator has executed his last will and testament by appointing the petitioner as sole executors of his last will and testament in presence of 2 attesting witnesses. So for the petitioner submitted, the petitioner and the testator died on 5th of August 2020. And the wife of the testator was predeceased to the testator, who died on 14th May 2020. The testator died leaving behind 2 legal heirs, that is 1 daughter, 3 legal heirs.
3 legal heirs.
3 legal heirs, that is
1 is the
2
executor.
daughters and 1 son. Out of 2 daughters, 1 is the petitioner, 1 daughter is the petitioner before this court. Other 2 legal heirs have neither come forward to give affidavit of consent or file affidavit in support of caveat. Accordingly, citations were issued. In spite of issuance of the citations, none of the legal heirs have come forward either for consent or for file affidavit in support of caveat. File affidavit in support of caveat. The department has submitted no caveat certificate dated 16th December 2024, stating the fact that as per record, no caveat has been entered against the grant of probate. Counsel for the petitioner submitted as no caveat has been lodged. Petitioner submitted to prove the will. The petitioner has filed the affidavit of one of the attesting witnesses. He submitted that the petitioner has proved the will and is entitled to get the probate. Had the learned counsel for the petitioner produce the original will, death certificate of the testator, death certificate of the wife of the testator, affidavit of the attesting witness, and no caveat certificate issued by the department. The affidavit in the affidavit, the attesting witness, namely Sarat Chakravarti, has categorically stated that the testator has executed his last will and testament in his presence and in presence of the another attesting witness, while possessing good health and fit state of mind, by appointing the petitioner as sole executors of his last will and testament. It is reflect from the certificate, no caveat certificate of the department, that no caveat has been lodged. Considering the above, this court finds that the petitioner has proved the will and entitled to get the probate. The department is directed to issue probate to the petitioner of the last will and testament dated 18th of December 2020 on compliance of all formalities. PLA number 2020.
Your lordship's kind pleasure, my lord, to grant the probate without order being drawn up, my lord.
Department is directed not to complete and drawn up the order.
I am deeply obliged.
I beg to appear, my lord. My lord, my
You
lord,
have given the line to all the
my lord, the rule says, my lord, is not required. That is why, my lord. All the years, my lord, in intestacy, my lord, has given consent, my lord. Will, my lord, is at page 12 to 17. Executor is in.
Take appropriate step for proposed amendment. After the amendment is carried out, petitioner that is over.
Yes, yes. Page 4A.
Yes.
All the years, my lord, have been substituted and
1,
my
2,
lord.
3, 4.
Yes, my lord.
4 legal years.
4 legal years.
Yes.
Consent given, my lord. Consent was.
All 4 legal
yes.
years. Where is the will?
My lord, page 12 to 17.
92.
Salt Lake. Salt Lake.
Where is the explanation?
My lord, I have given in. Para 2.
Para?
2. From the middle, my lord.
Yes. What is the name of the testator? Nikunja.
Yes,
Bihari.
Nikunja Bihari.
Where is the name of the executor?
My lord, page 12.
Executrix.
Executrix.
Suman Lata.
Yes, my lord. Page 13.
Suman
Para 2.
Lata
Kankaria.
Karkia.
Karkia.
Failing with Saroj. So see the Suman has filed this.
Yes,
petition?
yes.
What is the date? Yes. Two interesting. What is the date of death?
Date of date is, my lord, page 11, 13th
2001.
of 1 month.
2001. What about the wife?
My lord, I annex the death certificate. Page 18. And one son, page 19.
What is the date? 2000.
2000, my lord.
One son.
And one son died, my lord. His death certificate is page
24. You file the application 23.
23.
So after the amendment it is.
After the amendment.
So these are the 4.
Yes, ma'am.
1, 2, 3, 5.
4. 4.
Affidavit
First son is died. Ovijit died.
Avijit died.
His wife, his daughter, and daughter of the deceased, and another son of the deceased.
Sarabani.
Saha. Saboni Saha.
Then
Anusua.
Yes.
Thereafter, my lord, Nomita De.
Nabanita.
And Vishwajit Saha.
Yes. Attesting witness?
Yes, my lord. Proloy, by Proloy, my lord. Proloy Chaudhary.
Pralay Chaudhary.
Yes, ma'am.
So appearing for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament dated 21st of July 21st of July 1992. Counsel for the petitioner submitted. The testator has appointed the petitioner as executrix of his last will, failing which Srimati Saroj Karkia, Kharki. Counsel for the petitioner submitted. The testator died on 13th July 2001. The wife of the testator died on
18th May.
18th May 2000. And during the pendency of the suit, at the time of filing of the suit,
Application, my lord.
At the time of filing of the present application, two legal heirs were alive. That is the widow of the testator. Why widow?
My lord, it was not within knowledge. That is why, my lord, after amendment.
At the time of filing of the application, the petitioner has described two of the legal heirs of the testator as wife and one son. But subsequently, when the petitioner came to know the wife has also expired and son has also expired, accordingly, the petitioner has filed an application for amendment for deletion of the name of the wife of the testator who died on 18th May 2000. And after the death of the son, the legal heirs of the son have been added as has been disclosed, and details of the legal heirs of the son of the testator have been disclosed in the present application. The son of the testator died leaving behind his wife, two daughters and one son, being the daughter-in-law, granddaughter, wife, daughter, and son. One son.
Wife, my lord, two sons
and one daughter.
One daughter.
No. Two daughter, one son. Granddaughter. Why you give granddaughter?
Testator.
Then the other one is a daughter.
One daughter. Two sons, one daughter.
No. In the
page 4A, my lord, that is amendment.
Page 4, Tarulata, wife. Arijit Shah.
Abhijit. Yes. My lord, kindly come to 4A, page 4A. That is handwritten after amendment.
Achha, this Abhijit was not added there.
Yes, ma'am.
Earlier.
She was added. His name was wrongly spelled out.
He was Abhijit. Not Arijit.
Arijit, my lord, wrongly spelled out.
That's why he was Abhijit, not Arijit.
Yes.
Kya bola? The son of the testator died, leaving behind his wife, and one daughter. That is the daughter-in-law of the testator and granddaughter of the testator. The testator also left behind is another daughter, namely Namita De Sarkar, and one son, Biswajit Shah. Accordingly, the petitioner has made amendment in the probate application by bringing all the legal heirs of the testator on record. After the amendment, notices were issued to all the after the amendment, all the legal heirs have filed their affidavit of consent, stating that they have no objection for grant of probate of the will to the petitioner. One of the attesting witness, namely Pralay Chaudhary, has filed affidavit stating that the testator has executed his last will and testament in his presence and in presence of another attesting witness while possessing good health and fit state of mind by appointing the petitioner as executrix of his last will. Consider the submission made by the counsel for the petitioner, produced the original will, death certificate of the testator, death certificate of the wife of the testator, and death certificate of the son of the testator. This court also consider the affidavit of consent of all the legal heirs of the testator, as well as the affidavit of the attesting witness. The legal heirs have categorically stated that they have no objection for grant of probate to the petitioner. Full stop. The attesting witness have also categorically stated that in his presence and in presence of the another attesting witness, the testator has executed his last will and testament while possessing good health and fit state of mind by appointing the petitioner as sole executrix. Full stop. This court find that the will is dated 21st of July 1992, but the petitioner has filed the present application for grant of probate in the year 2023, in the month of July 2023. Counsel for the petitioner has categorically explained the delay as to why the petitioner has not filed the approved application immediately after the death of the testator. It is fine from the explanation that the original will was not traceable. Subsequently, only on 25th of May 2023, the petitioner got the will from the bunch of old papers, and immediately the petitioner has filed the present application. This court has satisfied with the explanation given by the petitioner for not filing the probate application immediately after the death of immediately after the death of the testator. Considering the above, this court finds that the petitioner has proved the will and entitled to get the probate. Accordingly, the department is directed to issue probate to the petitioner of the last will and testament dated 21st of July 1992 on completion of all formalities. PLA number 258 of 2023 is disposed of. Department is directed not to draw off and complete the order. Grateful ones.
So my lord rises. I apologize at the outset. My lord, I will be mentioning item number 115 and 116 of my lord's list testamentary matter. The difficulty is whether the petitioners are senior citizens, otherwise these are non-contentious matters, your lordship. It could be upgraded.
What is the age of the
65 years, but
65 is not a senior citizen.
From my lord several
By your side, see.
my lord. I understand, your lordship, but the difficulty is, my lord, they are actually suffering from various illness, your lordship. That is why, if my lord humbly praying, if it could be upgraded, my lord.
After 1 week, after 1 week, let some matter be disposed of, then I will consider.
My lord. Monthly list, my lord, item number 1, only
My lord, item number 63, my lord.
this matter, my lord. There are two applications which were before my lord. One is by my application for order is under order 39 rule 1 and 2 for temporary injunction, and the other is an application taken out by my learned friend with regard to
Order 7 Rule
temporary
11, demurrer and revocation of clause section 12A leave under the Commercial Court Act.
Lord, Mr. Shane was addressing my lord on this particular matter, and he had placed the facts and certain judgments in the matter as well.
My lord, we were to continue our arguments today. My senior is on his way, my lord. Till that, I can just recapitulate what has happened and then I can start.
Mr. Shane had relied on a judgment of proactive engineering of this
Two
court.
judgments, my lord, proactive and Yamini. my lord.
Yamini, he was supposed to place before my lord today. He
Yeah.
had indicated he would be relying on that judgment. It
My lord.
is more in the lines of the
Just to recapitulate, my lord, the primary point of contention was that there is no urgency ground made out in the plaint for any interim order. My lord, with regard to urgency, they have cited a police complaint of 28th February 2024.
Yes.
Which was with regard to unknown, unidentified persons, and not any complaint was made against the answering defendants here, my lord. Second, my lord, they again relied on a complaint made to police by defendant number 10. Defendant number 10, where he, my lord, I am led.
But I had commenced my submission on the last occasion, my lord. The first point which I had argued, probably your lordship has also noted, my lord, the revocation of the section 12A leave. For that, my lord, I had submitted a one-page list of date to show firstly that there was an earlier suit. List of events. It's just a list of events, my lord. Kindly see, my lord, 17th October 2023, a previous plaint on the self-same cause of action was affirmed. So, cause of action has started before this date, leading to the affirmation of the earlier suit. Then 18th October, suit was numbered 231. 24th January, that suit was withdrawn with liberty to file afresh on the self-same cause of action. Now, therefore, my lord, my submission was, my lord, if you let, I just show your lordship that order once, my lord. Yes. The order to the yes. Now, my lord, for 24th January, that suit was withdrawn. This suit was affirmed on 1st of March 2024. Now, in that perspective, your lordship will kindly see paragraph 13 of the plaint, which is yes, page 28 of GA2.
Yes.
So, my lord, their case of specific performance starts from paragraph 13, where they say that they have requested 4 and 5 to execute deed of conveyance in their favor.
Yes.
And the same was delayed on various grounds. Then, my lord, paragraph 14, kindly see. In view of such deliberate delay, the defendant number 10, who was appointed as negotiator for eviction in consultation apart from the agreed to and decided to hand over 3 kata premises such and such to and handed over the said land to the plaintiff. So, July 22, he claims he has got possession. I am just giving lordship the date to relate to the first plaint.
Yes.
Then, my lord, paragraph 15. Plaintiff has issued several notices upon the defendant calling on them to perform their obligations.
Yes.
In spite of reminder, defendant chose not to take any action to execute deed of conveyance in the favor of the plaintiff in respect of the Schedule B property. So that is his cause of action. When I have given you notice, you have not responded to execute the deed of conveyance. Thereafter, several notices as stated below were issued. Defendants chose to ignore all notices. On 6th October 2022, the learned advocate requested defendant number 4 to execute registered deed of conveyance in connection with memorandum of understanding dated 4th March and 7th April. Lastly, on 10th April 2023, when notice was issued to defendant number 4, and 3rd October 2023, notice for registration was issued on defendant number 1 and 2 for execution of deed of conveyance with a copy to the other landlords. In reply thereto, defendant number 4 through his advocate's letter dated 12th May 2023 declined to execute deed of conveyance. Lastly, so this forms his cause of action for the earlier plaint, and based on the 3rd October notice of registration, he had filed the earlier suit on 17th October. Now kindly see, my lord, that came to be withdrawn on 24th of January 24.
Yes.
This is page.
This is plain. The plain first.
Oh, but this order is annexed to the plaint itself. The original plaint, I think it is just after the concise statement.
Okay, that is not
Very
denied.
not a problem. Then, my lord, kindly comes to paragraph 18. Just kindly note the date suit was withdrawn on 24th of January 2024. So next cause of action, my lord, kindly see which he pleads here is paragraph 18. On and from first week of February 2024, plaintiff was confronted with unwarranted harassment from unknown unidentified men.
Yes.
With their sole objective to dispossess him from B schedule property. Such actions took place on various occasions thereafter. Subsequently, the plaintiff, while under constant threat of being forcibly evicted from the Schedule B property by local miscreants, lodged a complaint on 28th February 2024. Photocopy of the complaint is annexed here to a mark as letter N. First thing is, well, this cannot be the cause of action against me or the urgency because it is from unknown unidentified men.
Yes.
Not case that I am trying to disturb him. So that will give him a cause of action even after withdrawing the earlier suit. Otherwise, his cause of action against me is the earlier suit itself.
Yes.
Now, my dear lordship can make a note, this complaint which he has annexed as annexure N to the plaint, this is not against me. If your lordship kindly takes page 761, which is, auto volume bolo dao to? Volume 6 tag bade. Plain.
ये कौन सा है?
I Mohesh Thakur such and such.
Page
761. Annexure N.
Yes.
So I am, can just see that I am not named here.
Yes.
Similar, my lord, paragraph 19. He says that plaintiff has come to know that defendant number 10 has lodged a police complaint on 13 February 2024. Defendant number 10. That is 762.
Yes.
So this is not his cause of action. Complaint of defendant number 10.
Yes.
So therefore, my lord, my submission before your lordship on the last occasion was paragraph 22, your lordship will come.
Yes.
It has come to the knowledge of the plaintiff that defendants are trying to proceed with a development agreement dated 10 September 2020 and trying to construct high-rise multi-storied building by demolishing existing structure over premises number such and such, even when plaintiff is in due possession of the Schedule B property. Subsequently, plaintiff made inquiries before concerned department regarding any proposed project work, and to which Kolkata Metropolitan Bureau issued notices raising certain queries about the prevailing situation concerning it. Documents evidencing such attempts made by the defendants for getting statutory clearance and reply notices. Your Lordship will see all these documents which are part of Annexure P relate to 2023 from 768 onwards.
Correct.
That means those were his cause of action for the earlier suit.
Yes.
Of the October suit. Now, when he has withdrawn that suit, then unless something is pleaded against me, which he cannot wait for mediation, that has to be his cause of action to get a Section 12 relief, not otherwise. If you are otherwise proceeding with the cause of action of the earlier suit, then 3 months there is nothing. Why should the court grant you leave for dispensation? So this is my point which I had argued for the purpose of revocation of 12A leave, and I had cited
2024.
yes.
Proactive shift management.
I am sorry, Manoj, I just missed out paragraph 31. Kindly see also paragraph 31 of the plaint.
Yes.
Cause of action of the present suit arose on first week of December 2014, when the plaintiff had made payment of 1,95 crore to the defendant numbers 1 and 2 for the first time and has been continuing, and also on 7th May 21, when the time period of 1 month for deed of execution of conveyance with the 3 kata land expired, and subsequent thereto after obtaining possession in the year 2022. Thereafter, when advocate of the plaintiff issued notice dated 10th April 23, 3rd October 23 for execution of deed of conveyance with a copy to the other landlord, but the same was denied. So therefore, after 3rd October, your last date of cause of action, you filed the suit, earlier suit. So therefore, there is nothing which you say of impeding urgency for which you cannot go to mediation.
Yes.
So this I had tried to, I think, copy 2023 SCC online SC.
Yes. Yamni Manu.
Yes, yes.
Yamni Manu and
And
2024 SC.
paragraph 10 and 11, I think I had relied. 10, 11, 12.
Yes.
And also, Manoj, I had relied upon a Calcutta High Court which says that revocation of leave under.
Just
For SCC online Cal 1838.
Yes. Proactive shift.
Yes, that is only for that revocation of leave under 12A is permissible and when it can be granted.
Yes.
I had placed on, my lord, paragraph 10 onwards.
Yes, till 20.
Yes.
And 26 onwards. Yes.
Yes, that is it. In fact, 28 was Order 7, Rule 11 be pressed into service on a subsequent no urgency finding of the court. So this was my, if your lordship wants, I just place the highlight.
No, it's, I have taken note.
Very good.
Already.
Then I am not going to.
Paragraph 29 is the.
Yes, 29 is the main thing.
Yes, that's all.
Yes. Now only one more point, my lord. The second aspect or ground I have taken, it does not disclose any cause of action. Why I say this? But if your lordship takes the prayers in the plaint, they are asking for direct the respondent numbers 1 to 5 to execute deed of conveyance in favor of the petitioner in respect of 3 kata land. Now, my lord, 1, and therefore they have to plead specific agreement by the owners of the property No one other than the owners can execute the deed of conveyance or be compelled by a decree of specific performance. Now see, my lord, their own statements in the plaint. Kindly comes, my lord, to paragraph 3. Yes, if your lordship sees, according to paragraph 3 case, who has approached the plaintiff? Respondent number 1 along with respondent number 2. Approach the petitioner offering such and such consideration price. Then, my lord, respondent number 1 and 2, upon approaching the petitioner, made several representations. What is the representation? Who is the owner? Kindly see. They have represented that 1 and 2 is not the owner. Several deeds of conveyance. One Dream Home Private Limited, that is respondent number 3, respondent number 6, and respondent number 7, had jointly purchased the property measuring such and such. Then kindly see paragraph number 4. Towards the middle, relying on such representations.
The paragraph 3.
Yes.
Defendant number, who is the owner?
Owner is A, para A. By several deeds of conveyance, enter into by and between owners of premises number such and such, more fully described in schedule of the One Dream Home. Now defendant number 3.
You.
I. Defendant number 6. And defendant number 7.
So you are appearing for 3 to 5.
I'm 3.
3 and 5.
3
to
4,
5.
5. Directors also.
So now the defendant number 3, that is a Dream Home Private.
Yes.
And the defendant number 6, you are not appearing. Have jointly purchased the said property.
Yes. So we are the 3 joint owners.
Correct.
And that was told to them by 1 and 2. That is the case.
Yes.
So it is not that respondent number 1 and 2 has misled. Respondent number 1 and 2 has told them that we are not the owners.
Correct.
3 persons are the owners.
Yes.
Now kindly see, my lord, paragraph 4. 3
of the plaint.
Now kindly come to paragraph 4. 4 towards the middle, relying on such representation. Relying on such representations made by 1 and 2, petitioner decided to accept the offer made by 1 and 2. Petitioner states that all such offers were made oral. Then upon acceptance, a little down, upon such acceptance of the offer by the petitioner, the respondent number 1 and 2 further requested the plaintiff to immediately make payment of approximately 2 crores in cash, as the defendant number 1 and 2 are in dire need of funds for the purpose of their business. In view of such request, plaintiff in full faith paid a sum of rupees 1 crore 95 lakhs to 1 and 2. So not to the owners.
Yes. In view of the request from defendant number 1 and 2, plaintiff in full faith had paid itna to whom?
1 and 2. It was a request by defendant number 1 and 2. Yes. As it was the practice between the plaintiff and defendant number 1 and 2 to carry on such cash transactions. Yes. Oh, the next line is there. Such payment was made by the plaintiff to defendant number 1 on diverse dates in the month of December 2014. Defendant number 1 have admitted such payment on various decisions. So this, up to this, owners does not come in.
You are not there.
I am not there.
Okay.
Then your lordship will kindly see para 5. Para 5. Plaintiff states that since certain clearance from government authorities were pending in respect of the said land offered by defendant number 1 and 2 to the plaintiff, against which plaintiff had already made payment of 1.94 CR in cash, payment of balance money was kept pending as per advice of 1 and 2. Sometimes in November 2017, defendant number 1 and 2 represented to the plaintiff that such clearance had been obtained, and as such balance payment of 30 lakh were called for by defendant number 1 and 2. When the plaintiff said that such payment would be made by way of check, the defendant number 1 requested plaintiff to issue check in favor of the defendant number 9, company of which both defendant number 1 and 2 were directors. So again, none of the actual owners have been paid. As such, plaintiff, as per instruction of 1 and 2, issued 2 several checks in favor of defendant number 9.
Yes.
Now paragraph 6. Plaintiff, after making entire payment of 2 crore 25 as stated herein above, duly called upon the defendant number 1 and 2 to execute deed of conveyance in favor of the plaintiff. So there is no cause of action against me for a specific purpose. However, on some pretext or the other, defendant number 1 and 2 postponed and or delayed execution of deed of conveyance whenever plaintiff it was represented that since the defendant was suffering. So this is the thing. Now, if your lordship comes to how do I come in? Paragraph 7, lordship will see paragraph 7, where these subparagraphs start, just before that.
Yes.
Upon being it starts with as such when the unlock period started. Lordship got it? Page 9.
Page 9, yes.
Yes. As such, when the unlock period started, plaintiff tried to get in touch with 1 and 2, and finally in March 21, the plaintiff could confront the defendant number 1 and 2, calling upon them to execute deed of conveyance in respect of 6 kata land, for which he had made entire payment long back, when last of payment was duly received by the defendant in November 2017. Upon being so confronted, defendant number 1 and 2 made the following admission to the plaintiff, wherefrom the plaintiff for the first time became aware of fraudulent and unscrupulous acts and activities of 1 and 2.
Yes.
How can it be fraudulent and unscrupulous act? In the first paragraph, you have said that they have represented that they are not owners. Such admission made by defendant number 1 and 2 are stated below.
So you are not there in.
I am not there. Here they say name of dream home comes. A. What is the admission? That name of dream home company holding 25% share in Edu property was changed to Kanhaiya Realtors. How can it be an admission later? Because in paragraph 3, your lordship has seen respondent numbers 1 and 2 had represented to them that we 3 are the owners. So then, my lord, they have written entire everything that I am the owner of the property. Now, ultimately, if your lordship sees, they are trying to come to me on the basis of
Is there any transaction between you?
Yes,
Have you
kindly come
received-
to paragraph 12. Paragraph 12. They have referred to memorandum of understanding. Under the aforesaid circumstance, in continuation with the memorandum of understanding dated 4th March 2021 and subsequent discussion dated 5th April 2021, a memorandum of understanding was entered into by and between defendant number 1 and 2 with the plaintiff. I am not there. On 7th of April 2021, defendant number 1 and 2 took the entire responsibility to execute deed of conveyance in respect of the said land in favor of the plaintiff, and also made unequivocal admission regarding payment of entire consideration in respect of the said land. In the said under it was admitted plaintiff had paid consideration 2 crore 25. Said amount has been duly accepted by defendant number 1 and 2. So you are relying upon an agreement which you entered into with 1 and 2, where you say that the 1 and 2 had taken the responsibility of the conveyance. So how do you get a decree for specific performance against the actual owners? Where is my agreement to you which the court will enforce? And my lord, before this, there is another agreement they have referred to, which is at page
11, page 11G.
yes, at page 11.
11 of
This of the petition.
Plaint.
Plaint, it will be part of the plaint. Running page 22 at G, subpara G.
Yes.
It was further informed by defendant number 1 and 2 that on 4th March 21, a memorandum of understanding was entered into by and between defendant number 1 and 2 representing Bhartiya Group on one part, with Sushil Agarwal and Surendra Agarwal being defendant number 4 and 5 representing Mittal Group, wherein several understandings relating to joint projects between Bhartiya Group and Mittal Group were arrived at. Plaintiff is not a party to this.
Yes.
One of such project was the Khanna project.
This is with regard to paragraph
Blood
7G.
Yes. 7G.
7G. Yes.
One of such project was the Khanna project, being a project in respect of the Schedule A property. It was informed by defendant number 1 and 2 that in the memorandum of understanding, the agreement arrived in respect of the Khanna project was subject to clearance from the plaintiff, which was mentioned in the memorandum of understanding.
Yes.
So, my kindly see their case of specific performance is dependent upon a memorandum of understanding between defendant number 4 and 5 and 1 and 2. And another agreement between plaintiff and defendant number 1 and 2. So there is no agreement between the owners and the plaintiff for sale. There has to be cause of action must disclose an agreement for sale, either oral or written. Written is very easy, but oral is also not there. And admittedly, in your own case, you have said that I have proceeded on the basis of the offer made by 1 and 2, who represented to me that 3, 4, and 5 are owners. I have paid to 1 and 2. Now I have asked 1 and 2 to execute conveyance. 1 and 2 has avoided. Then after the unlock period, I have come to know of these facts. What facts you have come to know? That there was an agreement between Bhartiya Group and Mittal Group. And the plaintiff has entered into an agreement with the Bhartiyas. Bhartiya has taken responsibility for sale. Let them take responsibility for sale. How will the court enforce the agreement against me?
Yes.
And I think, my lord, this is a plaint, my lord, which deserves to be nipped in the bud at the first stage.
Yes. That's all.
I think, my lord, these are my submissions. And your lordship, my lord, being that is not relevant here, that there was no interim order was granted at all on the basis of all these submissions. My lord.
Yes.
Now, Lordship, a lot has been said on the first point by my learned friend regarding an earlier suit, withdrawal of the suit, an order passed in that withdrawal. Unfortunately, my lord, subject to correction by my learned friend, I don't find a single pleading in the. There's nothing on record in the petition or the plaint about the first point taken by my learned friend. Your lordship knows, my lord, all the submissions in respect of point 1 regarding a prior suit which was withdrawn and thereafter this particular suit was filed was made from the bar. Nothing on record to show that. Now, so far as I'll take your lordship through the petition that has been filed by my learned friend.
Yes.
The first opening line in the first paragraph, my lord, I hope the GA1 is there with all the volumes because
Yes.
because the annexure to DA1 is the annexures to the plaint, my lord. I would like to
DA1?
refer to those. J1 এর সব both the applications are appearing before your lordship. Now the opening line of the paragraph 1 of the petition says the petitioner defendant number 3 is the undivided 25% owner along with the defendant number 6 and 7 having undivided 38.5% and 36.5% respectively in premises such and such. My lord, there is no dispute regarding that, my lord. Your lordship will take up my plaint being annexed to the application, my lord. Paragraph 3, which was placed by my learned friend, it starts at page 15. My lord, may I place this?
Of J1?
J1. J2, sorry, my lord. J. I would like to refer to the annexures to the plaint in the volume of the J1. Because the plaint is voluminous, the J1 is voluminous, that is why I inquired, my lord. My lord, paragraph 3, it starts at page 15 of J2, my lord. The plaintiff states that sometimes in December 2014, the defendant number 1, along with the defendant number 2, approached the plaintiff. The last line, my lord, I'll skip that. The defendant number 1 and 2, upon approaching the plaintiff, made several representations to the plaintiff more fully stated herein below. That by several deeds of conveyance entered into by and between the owners of the premises number such and such, more fully described in the schedule of the said deeds of conveyances, one Dream Home Private Limited, now the defendant number 3, the defendant number 6 and the defendant number 7 had jointly purchased the said property measuring 39 kata, 3 chitaks and 8 square feet and had become joint owners of the said property more fully described in Schedule A. My lord, I have annexed those deeds of conveyances. If your lordship takes up...
Not denied.
No, I am not on that matter. I did not deny. It is my case that the defendant number 3 was the owner. It is my learned friend's case that the defendant number 3 was the owner. Defendant number 3. No.
Ownership.
Now your lordship to GA1 এর volume 1 আর 2 টা
page.
My lord, GA1 volume 1 page 38 to 36, my lord. I have annexed the 7 deeds of conveyances. Now, if your lordship, it starts at page 38, my lord, this indenture made on 30th January between such and such.
38 to 30?
67, my lord.
Yes.
Now, if your lordship comes to page 41, my lord. And whereas a deed of conveyance dated 14th August, my lord, my lord, from the page 41,
yes,
from top 5th line or so, Dream Home Private Limited, a private limited company within the provisions of the Companies Act.
Yes.
My lord, the defendant number 3 prior to a point of time was known as the Dream Home Private Limited. Now your lordship comes to the executing portion of this document at page 54. The signature of the party start at page 54.
Yes.
Lordship will turn over to page 55. Om Prakash Bhartiya, Dream Home Private Limited, Om Prakash Bhartiya, Director.
Yes.
So, my lord, Om Prakash Bhartiya is the defendant number 1.
Yes.
The deeds of conveyances were signed by Om Prakash Bhartiya on behalf of Dream Home Private Limited.
Yes.
Defendant number 3, my lord.
Yes.
Now your lordship will take up volume 2. My lord, your lordship will also come to page 68. My lord, all this deeds, it's not required. My lord, all 7 deeds were signed by Om Prakash Bhartiya on behalf of Dream Home Private Limited as the director.
7 deeds.
All 7 I have annexed.
Correct. As director of whom? Dream Homes Private Limited.
Dream Home Private Limited. The stamp is there. If your lordship takes up
Yes,
once again page
Yes, I got it.
54, 55, my lord. The first deed of conveyance. All 7 I have annexed.
Prakash Bharti is the D1.
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 Now, if your lordship takes up volume 2 of GA1, my lordship, page 229.
$229.
229.
Yes.
Lordship has found it. My lord, list of shareholders, Kanaya Realtor Private Limited, the present defendant number 3. List of shareholders as on 31st March 2019. Name of shareholders, if I may read out, my lord. Surendra Agarwal, Sushil Kumar Agarwal, Om Prakash Bhartiya, Nikunj Bhartiya. Defendant number 1, 2, 3 and 4. 4 and 5, my lord. Defendant number 3 is Kanaya Realtors Private Limited.
Shareholders of defendant number. Shareholders of the Kanaya Mahal. Kanaya
Yes,
is the
ma'am.
defendant number.
3.
Is the defendant number.
Kanaya Realtors Private Limited is the defendant number 3, who is the owner, admittedly the owner.
Okay.
Now, my lord, the constant case made out by my learned friend that I was aware that the property did not belong to defendant number 1 and 2. It belonged to defendant number 3, 4 and 5. And knowingly I had entered into an agreement. That is not correct. The records will speak for it.
So as per the case, after going to the record, you find that he is one of same.
Absolutely. And I have produced those records with the,
Okay.
as on 2019,
Yes.
they were the shareholders.
Yes.
Now your lordship will come to page 233, my lord, of the same plan.
Yes.
My lord, these starting from page 230 onwards, my lord, I have annexed the list of the shareholders from 2016 onwards up to 2022. And your lordship will see, my lord, the transfer, as I have stated in the plaint, has taken place during the financial year 2019-22, page 232, my lord.
2016 to
2022, I have annexed all the list of the shareholders.
Yes.
My lord, in my plaint, I have stated that behind my back, without my knowledge, some fraudulent steps were taken. And the shares of the defendant number 3 were transferred by the defendant number 1 and 2 in favor of the defendant number 4 and 5. My lord, your lordship will take up page 232. Lordship will see that in 2016-17,
Om Prakash, Sushil, Surendra.
yes. Well, this was transferred to, I have stated in my plaint that it was transferred to the Bhartiyas by the
Om Prakash Bhartiya, 400
Yes.
equity.
Yes, my lord.
Transferee Rukmani Devi Bhartiya.
Yes, my lord.
Correct. And Nikunj Bhartiya and Rukmani Bhartiya.
Yes, my lord.
That is 2019-20.
Yes, ma'am. In 2019, this transfer took place. And I was not aware of this. I came to know about, I pleaded in my plaint, I came to know about it much later after the unlock period.
This is defendant number 1 and 2. Of
Yes,
Chandan Roy transfer. Yep. Yes.
Now, your lordship will once take up the third volume, my lord, of GA1.
Rukmani is the party here.
Yes, my lord.
Rukmani is party.
No,
here?
no, no. Rukmini later on transferred it. I have stated that everything has been stated in the plaint. My lord, that will be the subject matter of GA1.
Yes.
Today I am indicating only for clarifying my position that
You have a cause
the stand taken by my learned friend that I was aware that they were not the parties and there is no cause of action against them. They were the owners and the defendant number 1 and 2 were not the owners. To prove that, my lord, I am showing this.
Correct.
Just to counter that statement. The rest of it will be dealt in the GA1. Now your lordship will take up volume 3, page 363. 66, my lord. It's a power of attorney which was given to a developer for development of the property.
Yes.
Your lordship has found page 366, my lord.
NST Housing Development.
Power of attorney to whom NST Housing Development Private Limited.
Yes.
Now your lordship will come to page 67, 367. My lord,
Om Prakash Bharti.
7th line from the top, my lord. Kanaya Realtors Private Limited, previously named and known as Messrs. Dream Homes Private Limited, a private limited company within the provisions of the Companies Act. My lord, your lordship will skip. Represented by one of its directors, Om Prakash Bhartiya, son of one such and such.
Sorry. Yes.
Now your lordship will come to page 376.
Yes.
Kanhaya Realtors Private Limited, Om Prakash Bhartiya, director. Date ta bolte tha? My lord, this was on 21st of February 2019.
Yes.
Now, my lord, if your lordship wants to see the since this was a registered power of attorney, my lord, the photographs and the thumb impression were also given. My lord, page 394, Om Prakash Bhartiya first.
Yes.
Defendant number 1, my lord. Okay. Look, there are several other documents from which the authorization of Om Prakash Bhatia will appear. My lord, my case, as made out in the plaint, was squarely on that every representation was made by the defendant number 1 and 2 on behalf of defendant number 3.
Where is it in the plaint?
I have not disturbed my learned friend when he was making his submission, my lord. Now, again, if I may place the paragraph which was indicated by my learned friend. Lordship will come back to the petition, page 15.
GA2.
GA2, my lord.
Page?
Page 15. The defendant number 1 and 2, upon approaching the plaintiff, made several representations to the plaintiff. My lord, the later part of paragraphs, subparagraph A, one Dream Home Private Limited, my lord, page 16, my lord. The last line of paragraph 15 I have read out. And again, subparagraph A, page 16, the later portion. One Dream Home Private Limited, now the defendant number 3, defendant number 6 and defendant number 7 had jointly purchased the said property.
Yes.
The ratio of shareholding has been given. All these are admitted, my lord.
Yes.
And then I have annexed the deed of conveyances. I don't have to say anything. I have annexed the deed of conveyances, which clearly show that Om Prakash Bhatia was the person who was authorized to take all steps and sign in the deed of conveyances. My lord, their case has made out that I knew, and they, defendant number 1 and 2 were not the owners. That is clarified. My lord, I have showed that the defendant number 1 and 2 were shareholders of defendant number 3 at that point of time. And they had approached me on behalf of the, and they have said that the defendant number 3 was the owner of 25% of the shareholding. But whether whatever I have stated in the plaint is correct or not, that is a triable issue to be decided at the time of hearing of the suit.
Okay.
But today, whatever I have stated in my plaint is there, supported with documents.
Yes.
Now, my lord, if I may read from paragraph 4 of the petition of my learned friend, GA2, page 6, my lord.
Yes.
From the averment in the plaint, read as a whole, it appears that the plaintiff claims to have entered into an oral understanding with the defendant number 1 and 2 for purchase of 6 kata of land of such and such, and pursuant thereto made payment of 1.95 crores in cash to the defendant number 1 and 2. It is further revealed therefrom that the oral understanding was entered into with the defendant number 1 and 2, despite, I pause here, my lord, I highlight this, despite being made aware by the defendant number 1 and 2 that the defendant number 1 and 2 are not owners of the property and same belongs to the petitioner, the defendant number 3, along with the defendant number 6 and 7. My lord, this, my lord, I have drawn your lordship's attention that the defendant number 3 at that point of time, Dream Home Private Limited, was a company of which the defendant number 2 and 1 and 2, both of them were shareholders, and the defendant number 1 was the director who had the authority to sign all necessary documents, enter into understanding on behalf of the defendant number 3. Now look at the next part. It is further revealed therefrom that the I have already placed this. Now the next paragraph, the relief claimed in the plaint,
Paragraph
5.
Yes.
The relief claimed in the plaint are in the nature of specific performance against the defendant number 1 to 5, requiring the petitioner, defendant number 3, 4, and 5 hearing to execute a deed of conveyance in favor of the plaintiff.
Yes.
The plaintiff in the plaint has not claimed to have entered into any agreement with the petitioners, defendant number 3, 4, and 5 herein, nor has the plaintiff alleged that any payment has been made to the petitioners, defendant number 3, 4, and 5. Hence, the plaintiff does not disclose any cause of action against the petitioner, defendant number 3, 4, and 5.
Yes.
Now, my lord, may I pause here? My lord, the petitioner number 3 is a company. My lord, I have stated in the plaint that the plaintiff number 1 and defendant number 1 and 2 had approached the plaintiff, stating that the defendant number 3 was the owner of 25% of the property and had made representations to sell 6 katas of from that 25% of the property and had taken money on, and all this while when the money was transferred, the offer was made, they were shareholders and directors of the defendant number 3. So it cannot be said and today that there was no understanding, no agreement with the defendant number 1 and apart from the defendant number 1 and 2. No, there was no privity of contract between the defendant number 3, 4, and 5 because, my lord, the defendant number 1, being the authorized person on behalf of the defendant number 3, had entered into an agreement admittedly with me and had taken money.
Got your point. Yes.
So the claim of my learned friend that there was no cause of action against the defendant number 3 and 4 cannot be sustained, my lord. Now, I would like to place plaint 3, the paragraph 3, 4, and 7 of the plaint, my lord. My lord, 3 I have already placed. Now, if I may proceed to 4, at page 17 of GA2, my lord. It is stated that since the plaintiff had a long-standing relationship with the defendant number 1 and 2 and had immense faith in the relationship of the defendant number 1 and 2, as such, the plaintiff in good faith believed the aforesaid representations made by the defendant number 1 and 2 to be true and correct. The defendant number 1 and 2 further impressed upon the plaintiff that since the plaintiff was in real estate business, the said 6 kata of land offered by the defendant number 1 and 2 to the plaintiff, being in a prime location of the heart of Kolkata, would be immensely beneficial to the plaintiff and his business. My lord, the representations are being made by 2 persons who are shareholders of the defendant number 3 and are directors. So I had no reasons to disbelieve them. Relying on such representations made by the defendant number 1 and 2, the plaintiff decided to accept the offer made by the defendant number 1 and 2. The plaintiff states that all such offers made by the defendant number 1 and 2 were oral, and considering the cordial and long-standing relationship maintained by the plaintiff with the defendant number 1 and 2, the plaintiff also accepted the same. So, my lord, my learned friend has submitted that there was no pleading of oral agreement. I have pleaded.
Yes.
Upon such acceptance of the offer by the plaintiff, the defendant number 1 and 2 further requested the plaintiff to immediately make payment of approximately 2 crores in cash, as the defendant number 1 and 2 were in dire need of cash funds for the purpose of their business. In view of such request made by the defendant number 1 and 2, the plaintiff in full faith had paid a sum of rupees such and such. As in past also, it was the practice of between the plaintiff and the defendant number 1 and 2 to carry on such cash transactions. Such payment was made by the plaintiff to the defendant number 1 on diverse date in the month of December 2014. The defendant number 1 and 2 have admitted such payment on various I think there is a typographical mistake. It's occasions. It should be occasions. All such payments were made by the plaintiff at the office of Dream Home Private Limited at 37A room number such and such, 2nd floor, Benting Chambers. My lord, that was the place of the registered address of the defendant number 1, the defendant number 3 at that point of time. So, my lord, I have made payment, and that would be borne from the memorandum of understanding which was entered into by and between myself and the defendant number 1 and 2. My lord, that is also my specific case that I have given it for being stamped. It is an unstamped document sent for being assessed and stamped. Because I cannot take advantage, rely on it, but for the purpose of collateral evidence, my lord, I can rely on that. Yeah. Now, Lord, paragraph 7. In the meantime, with the onset of the pandemic and the lockdown imposed by the government of India in view of such pandemic, my lordship will skip this. And the next sentence. As such, when the unlock period started, the plaintiff tried to get in touch with the defendant number 1 and 2, and finally, sometimes in March 2021, the plaintiff could confront the defendant number 1 and 2, calling upon them to execute the deed of conveyance in respect of 6 katas of land. After this, my lord, I came to know about this train of events which are I have stated in the sub paragraphs. The first thing that I came to know was that Dream Home Private Limited has been changed to Kanaya Realtors Private Limited. Yes. The second, the address of Dream Home Private Limited has been changed, and the new address was 6/7 New Shield Lane, Howrah, Sodor, outside the jurisdiction of this court. C. The shares held by the defendant number 1 and 2 in the defendant number 3 were transferred by way of gift in favor of Rukmini Devi Bhartiya, being the wife of late Ladduram sometimes in the year 2020. Thereafter, the said Rukmini Devi Bhartiya transferred her entire share in favor of Jayashree Agarwal, granddaughter of Rukmini Devi Bhartiya, by gift on February 15, 2021. The list of shareholdings, my lord, I have already shown your lordship the list of shareholding. Sometimes in the year 2019, the joint owners of the scheduled property, being the defendant number 3, 6, and 7, jointly decided to develop a multi-storied building at Schedule A premises, and on 31st of February 2019, 21st of February 2019, executed a development agreement with one Lakhu Ganges Realtors LLP. In the said development agreement, the defendant number 1 represented the defendant number 3 as one of its director and put his signature at the time of execution of the same. This also I have shown your lordship. Now, my lord, on 10th September 2020, the development agreement with Lakhu Ganges Realtors LLP was cancelled by a registered deed of cancellation. On 10th September, another registered development agreement registered by additional registrar of assurance, being such and such, the said joint landowners, being the defendant number 3, 6, and 7, entered into a development agreement with such and such. Now, thereafter, the several other defendants who are parties to the suit, I have made them parties because they are proper and necessary party for being for the adjudication of the instant suit.
Right.
For adjudication of the suit, for my the trial of the suit, my lord.
What is the necessity of their party as a party?
Because they are owners.
But where is the pleading with whether they are the necessary party or whether they are required to be?
My lord, I have stated in the plaint. My lord, this application is between the defendant number 3, 4, and 5 and myself.
Okay.
When I make my submission in respect of the defendant GA number 1, my lord, I will make my submissions.
3 p.m. So you have to stop here.
Tomorrow also it is fixed.
It's fixed tomorrow.
চেষ্টা করব
না আমাকে কি রিপ্লাই দিতে হবে সেই যেতে হচ্ছে if my learned friend finishes then I can give the
My lord,
reply.
both the applications are fixed before your lordship, my lord.
So I will finish the reply first in this GA2.
Then there. What is about the GA1?
GA1 has to be heard out also.
That is to be.
First, let us finish the GA2.
First, you come to one. Concessions for the plaintiff, concessions offering for the defendant number 129, concessions offering for the 329, 325, concessions offering for the 6 and 11, and concessions offering for the defendant number 7. Full stop.
Once the GA2 is decided, then it is better to go to
Let me complete it. Counsel for the defendant number 325 has concluded his argument in connection with GA2 of 2020. Counsel for the plaintiff has argued the matter in reply, but due to paucity of time, hearing could not be completed. Accordingly, case is adjourned. It is fine from the record. The matter is already fixed tomorrow. This the matter tomorrow at 2 p.m. Obliged. 2 p.m. है ना?
Yes.
Father fever. Yes. Call on.
Lord, I appear for the defendant number 2 and 3.
Yes.
I mean, Lord, today the argument on behalf of the defendant number 2 and 3 has to be, Lord, commenced, Lord. And Lord, on the last occasion, Lord, the facts were placed before Lordship.
ये बंद हो सकता
And
अकेला.
Lord, I had submitted that on issues wise. I will deal with the Lord, my argument. And before that, Lord, in short, I place Lord the some fact.
बिल्कुल बंद हो जाएगा. हाँ, नहीं ये बंद करना. इसको खाली बंद कर दो. बाकी चलने दो. अगर बंद होता है तो फिर रहने दो. अगर अकेला बंद होता है तो ठीक है. नहीं होगा तो रहने दो. Yes.
Lord, in summarily, Lord, I place the fact, Lord. Then I will go to the issues, Lord.
You already phrased the fact. Now come to the issue. Correct. You come to the issue. Last occasion I already stated.
Lord, yes. So,
You
Lord,
already stated with the fact.
yes.
Now come
So
to the
this
issue.
is, Lord, the contract for
Yes,
constructing
I
a bridge.
understand your
Lord. Then, Lord, the contract was terminated, Lord, by Lord invoking the provisions of clause 62, Lord, wherein the 7 days notice and 48-hour notice
Correct.
were duly served, and Lord, then.
So with regard to the maintainability, you already argued.
Yes, Lord, the issue number 1.
That you already argued.
Issue number 1, Lord, I dealt with first, Lord. That day I said that is the suit maintainable as framed. Lord, in answer to this, Lord, I say that the Lord,
But you will get only 15 minutes, 10, 15 minutes only.
Lord, today is this.
Yes.
Lord,
I have to leave by 3:15. I will leave.
I'm trying, Lord, as much as I
जिसका
can.
interim order है,
Yes.
3:15 में बुला देना. You are the lucky, not.
Yes. So, Lord, the issue number 1, Lord, the issue number 1, and the defendant railway submits that, Lord, that the instant suit is not maintainable as framed before this honorable court for the following reasons. 1, cause of action in instant suit has not arisen within the territorial jurisdiction of this court, and 2, Lord, defendant railway is not having any office within the territorial jurisdiction of this court. Then, Lord, the issue number 2, Lord, the issue number 2 is, Lord, whether the plaintiffs failed to perform any part of contract despite the same being achievable under the contract conditions. Lord, in answer to this, Lord, the defendant railway submits that the plaintiffs failed to perform its obligation to complete the project despite the same could be completed by the plaintiffs for the following reasons. One, my lord, as per chapter 12, special condition of contract, part 8, clause 5.1 and 7.1 provides for use of explosive
Yes.
in the process of sinking of wells, wherein it is clearly mentioned that no claim due to any obstruction met with during sinking or due to any other difficulties experienced in this process shall be entertained. My lord, may I place this, my lord? The special conditions of the contract. That is, my lord,
Issue number 2, fail to perform any part, whether plaintiff failed to perform any part of the contract despite being achievable under the contract conditions.
my lord. So here, my lord, the contention of the plaintiffs, my lord, my lord, inter alia is that it could not complete because there were hard rock. Therefore, it could not penetrate. So therefore, it could not be completed. So here, my lord, this chapter 12, special condition of contract, part 3rd, part 3rd, my lord, that this provides the use of explosive. This is mentioned in the my lord contract. Contract, 8 page. Special condition 12. You know, the special condition 12, that is at give me. I'm placing my lord further, my lord. You find out. My lord, in cross-examination of the plaintiff's witness number 1, in question number 283 and 284, my lord, has been recorded, my lord, as under. My lord, the
Serially रखा करो रे बाबू.
my lord, plaintiff number 1 is the witness of the my lord, witness 1 of the plaintiff.
280?
My lord, the question number 1, 283 and 284.
नहीं है इसमें. Is the chief? Where is the cross? For the examination chief.
Chapter 12, present chapter 12. Yes. My lord, I found the chapter 12, my lord.
to exhibit.
Question 283.
Milord, question number
Did the plaintiff apply before the defendant for granting permission for blast?
Yes, Milord. 283 and 284. Evidence to be
Whether the defendants, after receiving the information, request to carry out the blast at the well foundation.
The answer is, Milord, the plaintiffs kept the defendant informed of the situation. Milord, here in that chapter 8, Milord, kindly have a look first, Milord. That is the it's in chapter 12 of 5.1. No, chapter 12 होता है.
Drolia, this is not the way. You are taking time and not coming with ready.
Yes,
You are a junior. You are a.
exhibited. I don't think so.
No, it is exhibited. This is the
Which
contract
is
agreement.
Show the exhibit number. That's all.
Exhibit Milord D.
You have not mentioned your written notes. Which is the exhibit D?
Milord, this is the
Whether special condition is exhibited or not.
yes.
So
This
tell
is
that exhibit number and cause. That's all.
Milord,
The
this
court
is
will consider.
contract, Milord. This is contract exhibit D.
Exhibit D.
Yes, Milord.
Yes. Clause 12. Okay.
Milord.
Court will see to that.
So, Milord, here chapter 12, Milord, here it is specifically mentioned that is the 7.1, Milord, of chapter 12.
Chapter 12 condition
use
12.
of explosive.
Chapter 12 or condition 12?
The chapter 12 of the special conditions.
Special condition. Clause?
Milord, 7.1.
Yes. What is the condition?
Milord, use of explosive. Use of explosive. Explosive shall generally not be used as an aided and well sinking. However, in cases where the explosive are to be used, prior approval of the engineer shall be obtained. All prevalent laws concerning handling, storing, and using of explosives shall be strictly followed.
Correct.
If blasting has been used for settling the well after it has reached the designed foundation level, normally 24 hours shall be allowed to lapses before bottom plug is laid. All safety precautions shall be taken as per IS 4081 safety code for blasting. And Milord 5.1, 5.1, Milord.
Yes, now you have to stop here. I have no time. Come ready with all documents.
What is that, Milord? We are getting pressure.
What can be done?
But they, Milord, I don't think that
I
is developed.
Milord, I am here. I can go on for 1 hour. This is not.
Sense suffering for
me.
the plaintiff, sense suffering for the defendant. Counsel for the defendant has argued the matter, but
Ready means I will place my own way. Will you interrupt in that?
Let the matter. Up here. Give the date. अप्रैल में दे दो 3 डेट एक साथ दे दो खत्म कर देगा 19 9 10 11 April 2025 at 2 p.m.
Follow.
Milord, yes.
Item 43 of your lordship's list. The interim order is expiring today.
But my lord, this matter, lordship will remember, my lord, this was that suit for land which we had argued, my lord, ex parte order. Now, my lord, this was fixed. Kindly then fixes the date. Every time it's been extended, but the hearing cannot take place, my lord.
I do not
I
write
was
in the way.
I was in the midst of arguing the matter, my lord. Kindly fixes a date, my lord, and a time, my lord. Then
Come on, April.
maybe in March, my lord, sometime, because
में कोई date है?
this order has been shown to the courts in Alipur, my lord, and extensions
Sons
are
suffering for the plaintiff, sons
Okay,
suffering
ठीक, बोलो ना,
for the
बिल्कुल
defendant.
लागू
Counsel for the plaintiff
March
press
ठीक
for
है,
extension of time to time
345,
extension of
Rajiv.
time of the interim order granted earlier, which is going to be expired today. Counsel for the plaintiff defendant raised objection and submitted that time and again the case is adjourned and the defendant and the plaintiff is taking the advantage of the interim order passed by the appellate court.
I have got time from my lord's diary. 2 days, 345 in March I have got.
Yes.
Which day?
In view of the submission made by the counsel
बोले
for
जाओ.
the plaintiff, let the matter appear on 11th and 12th March at 3:45 p.m.
1 day if I miss, the other day I'll my lord get.
The interim order granted earlier, क्या date बोला? 11 and 12. And let the interim order granted earlier is extended till 18th of March 2025.
Grateful.
Or until
Deep
further
love.
order is taken.
Deeply.
Sometime in March. The same thing is going. What can be done? Yes.
His Lordship, item number 27.
He'll do rightly solve.
The interim
Yes.
order is still today, my lords. They have yet
Who is
to
for the
file.
other side?
We've also informed them, my lords.
So suffering for the plaintiff, so suffering for the defendant, counsel for the plaintiff submit the interim order granted earlier is going to be expired today and placed for extension of the interim order. In view of the submission made by the counsel for the plaintiff, interim order granted earlier is extended till 21st of March 2025 or until further order, whichever is settled. Let the matter. This matter is on the list.
Lordship, this is running in the list.
Let the matter remain in the list.
Item 27.
Can it be fixed in
Yes,
March, my lord? Can it be fixed in March?
I have not. I am fixing, but that I will not get the time. All the diary is fixed. Yeah, that's why I fix them. April 3 dates. Come ready. I will not give any adjournment. I will give 1 date to you, 1.5 day to you, 1.5 day to him. That's all. If you complete, I will close that. I am telling you.
Yes, 8, 9 and 10.
8, 9 and 10 April.
2 p.m. মিলো আর বলবেন না